Meet please, my lords. My lords, item number 41. Mr. G. Chaudhary has taken ill, my lord. So yes, Mr. G. Chaudhary has taken ill, my lord. He is not well. Item number 41. He seeks a short accommodation, my lord. The matter can be fixed on next Tuesday, my lord.
Stay matter.
Yes, my lord.
Okay, we vacate the stay whenever it is.
My lord, a short accommodation. My lord. He's
Will-
unwell. That's why he has made this prayer. Tuesday, my lord. He'll appear.
We'll vacate the stay. Come on for stay. You do it. You are very good. Your name is there, glaringly.
My lord.
The file.
My lord, on the last occasion, notice was issued by his honorable court.
Mr. Counsel, it would not make any
They have not
difference.
appeared.
It would not make a difference. You are fantastic counsel. Fine counsel will hear you. For this. Stay matters are to be finished. These matters are to be finished. Most probably the other side is not represented.
They have not yet appeared, my lord. They have
We'll
received
see
the copy.
if it is required to be dismissed on that day, today itself. These matters cannot go on. 2024 CRPIO. All CRPIOs which I have issued notice, most of them are finished. These are old matters. Next.
I'll inform Mr. Chaudhary.
You inform.
Please, your lordship. I beg to mention item number 37. Because if this matter becomes infructuous since the petitioner has died in the month of January.
37.
37. Lord.
Infructuous.
Petitioner has died, lordship.
Huh?
Expired. Petitioner expired, lordship.
Petitioner expired.
Lordship.
What is the matter about?
Lordship, the petitioner is elected as the president, Assam Veterinary Field Assistant Association. Thereafter, he was not allowed to join.
So against that he has filed.
Against that, we have filed a title suit.
Okay, you be there when the matter is called. I'll then pass the order.
Lordship.
Let me have a look at the file and then pass the order.
Lordship.
May it please the Lord. With the consent of the other side, I beg to mention item number 12, your lordship. I'm seeking a short accommodation in this matter. Can it be on 18/6, your lordship?
No, 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 no. It is to be finished today.
Deeply obliged.
Hmm.
Like, I beg to mention listing for one lordship. It should be an admission hearing, but it was.
Court number, where is Justice Pukon sitting? Go there.
For motion item 1.
Yes, what is your case?
My lord, pursuant to an advertisement, my lord, for filling up the post of driver, my lord, in the establishment of CGM Soyadio, my lord, the petitioner have participated. My lord, the petitioner has called for the interview and the skill test. He being successful, my lord. He was issued with an appointment letter, my lord. I will take a lordship to page 40, my lord, the appointment order, my lord.
Then
My lord, on thereafter, my lord, on 7th January 2025, my lord, he has gone to the office for joining, my lord. And accordingly, my lord, he joined the office, my lord, at 2:30 of that day, my lord. I have annexed the copy of the joining letter, my lord, at page 69, my lord.
Then,
My lord, on 7th, my lord, he has discharged his duties, my lord.
huh?
On 7th, my lord, he was allowed to discharge his duties. He has marked his attendance in the attendance register sheet, my lord. But
Then-
from 8 onwards, my lord, he was not allowed to continue his duty, my lord. So,
Why?
my lord, when we have obtained the information under RTI, my lord,
Hmm.
the information, my lord, lordship may kindly come to my lord page 54, my lord, 53, my lord.
Hmm.
This letter has been issued, my lord, by the district and session judge Soradio, my lord. And with reference subject above, reference, I hereby direct you to immediately hold the joining process. But by that time, my lord, the petitioner has already joined on 7th, my lord. He has started discharging his duties, my lord.
Then,
But because of these letters, my lord, I was not allowed to continue, my lord. And thereafter, my lord, on page 54, my lord, another letter was issued, my lord. So it says, my lord, to the learned CGM Soradio, my lord, that with reference subject above, you are hereby directed to cancel the appointment. I have not been communicated or nothing has been given by the my appointing authority, my lord, the CGM, my lord, till date, my lord. But I am not allowed to continue my duties, my lord. when you have sought information, my lord, what is the discrepancies, what has been found, my lord, as mentioned in this letter, my lord. The office of the CGM, my lord, has informed under RTI that such information is not available with them, my lord.
Yes.
I need some time.
Next week.
For a filing affidavit, my lord, I need time. For inspection, my lord, maybe next week.
Only simple question.
Yes, my lord.
Why not?
Why, my lord? Yes. There may be some discrepancy.
You should notice, we finish it before vacations. You should
Yes.
notice making it returnable on 26th of June 2025.
26, my lord.
Mr. Who appears no government. Mr. G. Bush appears on behalf of the respondent numbers 1, 2, 3, 4, 5, 6, 7. Pusto. None appears on behalf of the respondent number 1 on call. Pusto. Extra copies of the writ petition be served upon him during the course of the day. As regards the respondent number 1, the petitioner is directed to serve a copy upon the senior government advocate, D. Nath, during the course of the day.
1 and 3.
Huh?
3 the state will represent.
You know, you 1 and 3. Huh? Mr. G. Bush appears for respondent number 2, 4, 5, 6, and 7. None appears for respondent number 1 and the petitioner is aggrieved by the action on the part of the respondent numbers 5 and 7 in not allowing the petitioner to discharge his duties as a driver pursuant to his appointment made by the order dated 30/12/2024. It is the specific case of the petitioner that after the petitioner was appointed by the order dated 30/12/2024, the petitioner joined on 7/1/2025 and was also allowed to join, as would be apparent from his signature appearing in the attendance register. However, after 7/1/2025, the petitioner has not been permitted to join by the respondent numbers 5 and by the respondent number 7 at the dictation of the respondent number 5. And for no good, and it has been alleged that there is no reasons assigned in that regard. The respondents are directed to bring on record their stand by filing an affidavit on or before the next date. List accordingly. It's on 26th.
Okay, my lord.
Short affidavit.
27/1.
What?
27/1 letter, my lord. The direction, my lord, page 54, my lord. That may be 8, my lord. 27/1 letter, my lord. Letter issued by the district and session justice CGM to cancel the appointment.
Issue notice making it returnable on 24th of July 2025. Pustak. Mr. So-and-so submits that the communication dated 27/1/25
55, my lord.
be ought to be stayed, comma. This court duly takes note of that the petitioner was not permitted to join on 8/1/2025 as alleged, and the instant proceedings having been filed in the month of June 2025, this court is not inclined to stay the said order.
Supplementary item 42.
Eastbound
My lord,
26.
my lord,
Mr. Counsel,
my lord,
no. Ekdam no.
sorry, my lord, for that.
I was finishing the matter on 26, and now you have, don't try to act smart, Mr. Counsel.
Sorry.
Can't help it. Change.
My lord,
Next.
42.
Yes, Mr. Monto. You
My-
filed the
I
additional
have filed the
affidavit.
additional affidavit, my lord. That is on Monday I filed, my lord.
Where is the judgment?
Judgment, my lord, it is
Who died?
my lord.
Who died?
My lord, mother died, my lord, Sinu Das died.
Hemendra Das.
Yes, Hemendra Das originally, he was the, my lord, judgment debtor. He expired during the time of the second appeal. And during the second appeal also, my lord, Sinu Das, although she was substituted, but she was also died, but that not record, that was not brought in record, my lord. The now after her death, my lord, 1B, 1C, and 1B, 1E, my lord. 4 sons are survived, my lord. So it has been already substituted.
1A is
What?
Sinu Das.
1 is Sinu Das expired, my lord.
Ah.
Now Podum Das, Sopan Das, Utpal Das, and Jitumani Das are,
The sons of Hemendra Das.
yes, ma'am.
Now the execution proceeding is going against Hemendra Das.
Hemendra Das.
Hemendra Das. Okay.
That is 16 of this month. That is-
Heard Mr. P. Mohanto, the learned counsel appearing on behalf of the petitioner. Mr. Yeah. The petitioner herein, who is one of the legal representatives of the judgment debtor Hemendra Das, brackets since deceased, have filed the present proceedings challenging the order dated 16/5/2025 passed by the learned court of the Munsif number 1 Nagaon in Mizze case number 65/25 arising out of title execution case number 6/2013, whereby the application filed under section 47 of the Code of Civil Procedure was rejected. Pustak. This court, taking into account that the execution proceedings pertain to the year 2013 and the suit was of the year
106 of
2006, takes up the instant application for disposal at the motion stage itself. Pustak. The grievance of the petitioner herein is that she, along with Sri Sopan Das, Sri Utpal Das, and Sri Jitumani Das. No, she no, he, no?
He might.
He along with Sri Swapan Das, Sri Utpal Das, and Sri Jitumani Das are the legal representatives of late Hemendra Das, who was the judgment debtor. Stop. It has been the attention of this court has been drawn to the judgment passed by the learned coordinate bench in RAC number 185 of 2013, wherein the late Hemendra Das was substituted by his legal representatives. Full the Greek. In spite of that, the decree holders in title execution proceedings number 6 of 2013 is proceeding against the decree against the deceased judgment debtor late Hemendra Das without substituting the legal representatives of the judgment debtor. Full stop. This court finds it relevant at this stage to take note of the judgment of the Supreme Court in the case of, what is the name again? I forgot. Huh?
I have given the copy, my lord.
You gave another, what's the name? U?
VUTHIRAP.
No, V. V. It starts with V. Na? V.
Then, my lord, Uthirapathi.
UTH. Na?
UTHRAPATHI.
UTHRA.
PATHI. Property versus Ashraf Ali. And others.
You have a copy of it? Just
Yes, sir. This is one of the para, my lord, I smallly marked, my lord. This is a last big para, my lord. Last portion, my lord, is or is
Very difficult to pronounce. Finds it very relevant to take note of the judgment of the Supreme Court in V. Uthirapati versus Ashraf Ali, reported in 1998, 3 SCC 148, which lays out as to how the executing court is required to proceed when the judgment debtor had expired. Pusto. Paragraph 14 and paragraph 15 of the said judgment being relevant is reproduced hereinunder. Pusto. From a perusal of the above quoted judgment, it is seen that the Supreme Court had made it clear that there is no abatement if the judgment debtor dies and the legal representatives are not brought on record, and the execution proceedings remains pending on the file of the executing court. However, it in the case of the death of a judgment debtor, the decree holder could file an application to bring the legal representatives of the judgment debtor on record at any time. And the court can fix a reasonable time for the said purpose. And if the decree holder does not file an application for the aforesaid purpose, the court can dismiss the execution petition for default. It is also mentioned it is also observed by the Supreme Court that it is open to the decree holders to file a fresh execution petition in case of the death of the judgment debtor, impleading the legal representatives of the judgment debtor. And such a fresh execution petition, if filed, is in law only a continuation of the pending execution application. Thus, the one which was filed in time by the decree holders initially. Full taking into account the said law, as it is an admitted fact that the original judgment debtor, emender since deceased, had expired, and the same is very much apparent from the judgment and order passed by the learned coordinate bench in RSA number 185/2013, this court disposes of the instant petition, directing the learned court of the Munsif number 1 Nagaon, the learned executing court, to proceed with the execution case being titled execution case number 6/2013 by taking note about the death of the original judgment debtor and thereupon provide opportunity to the decree holders to file appropriate application for substitution of the legal representatives of the original judgment debtor. With the above, the instant proceeding stands disposed.
For admission, item 2.
Mr. Mohanta, you should be very careful because it is a continuation. So that 2 years won't come in.
Yes, ma'am.
The item may be taken up, can be taken after some time. The counsel for the petitioner is in legs at a virtual court for
Both the parties that the matter had been amicably settled and the parties would like. Settled?
Yes, your lordship. The matter has already been settled.
Settled. Good.
Because he's more, he's leading the case, so it might be
Who?
Mr. Pukashta,
Who is Mr. Pukasta?
petitioner,
How many Pukastas we have in the court?
A.K. Pukashta.
A.K. Pukasta. He says about that there is an amicable resolve, amicable settlement. Is it done?
Yes.
Did you file an appropriate application in that regard?
Yes, your lordship, actually, we have already signed the joint compromise petition to one.
Show me to me. Have you filed this?
Actually, the other side, the advocate has filed this petition.
Huh?
You are not the petitioner side, the petitioner side filed the petition. to one.
Hello. We take it up on merits now, this was. What is that order challenged? What is the order challenged?
1/8/2015, Your Honor.
Today is the date fixed for order on Ian. How is a 115 or 227 maintainable? Huh? Against this order? How is a 227 maintainable? Where is your senior?
He's in legs in virtual court. So,
Where?
He's taking a virtual court in the bar. So he'll be coming or he'll be free after some time. Can we take
Okay.
it?
Ask him, otherwise I dismiss it. Not necessary on this. This is a case for dismissal right here. Three.
Yeah, there's a lordship.
Hmm.
Intent order is at page 24, lordship.
What is this? What are you challenging?
Lordship, we have filed a petition under, it is in page number 18, lordship.
These are old matters pending.
Under order
Again,
26
whereby the
rule nine.
municipal had rejected the prayer made by heir for issuance of a survey commissioner for measurement of the suit land. The prayer was rejected on the ground that the same would cause delay in disposal of the suit. Now it just delayed so much. Yes, what do you want? Why are you opposing?
Only one thing is that page 10 lordship.
Is there any dispute pertaining to the boundary? Right?
Already lordship,
No. This question is very simple. Is there any dispute pertaining to the boundary?
lordship, yes.
Then rightly, this should have been allowed.
May I show one paragraph lordship? Paragraph, page 10, paragraph 5.
What?
Already that land, Lapmondal, Boitamari Revenue Circle has verified the land and it has been found that 11 lessa of land has been encroached by the defendant. So that has already been done. So it is in second inspection lordship.
Was there any commission earlier?
No, by not by this court. The circle officers, circle office persons has came to the land prior to filing of the suit.
So, but the court has to decide.
Lordship.
So this has to be
Otherwise
allowed.
also I am a performer.
You're a performer. Chalo. We allow your petition. Or Miss So-and-so appearing on behalf of the petitioner. Mr. D. Chaudhary, who appears on behalf of the
Respondent number 2.
respondent number 2. Respondent number 2. Most of none appears for the respondent number 1. This is an application filed under Article 227 of the Constitution, challenging the order dated 26/3/2017, whereby the application filed under Order 26 Rule 9 of the Code of Civil Procedure 1908, read with Section 151 of the Code, was rejected. Full stop. The case of the petitioner herein is that the case of the petitioner herein, who is the plaintiff, is that he had filed a suit, he or she had filed a suit for declaration, eviction, and cast possession from the encroached suit land measuring 11 lechas arising out of the total plot of land at measuring 0 biga 2 katha 10 lechas covered by dark number 252 and patta number 84 situated at village Kayapatti under Boitamari Revenue Circle against the defendants. Full. The defendants appeared in the said suit and filed his written statement denying the allegations of encroachment of the suit land along with other grounds. Full stop. It was stated, full stop, at the time of
Argument.
at the time of arguments, comma, at the time when the suit was fixed for arguments, an application was filed under Order 26, Rule 9 of the Code of Civil Procedure, of the Code, seeking appointment of a commissioner for the purpose of ascertaining as to whether there was encroachment of the 11 lechas of land as alleged by the plaintiff. Fusto. This application was rejected, and it is under such circumstances the present proceedings have been filed. Fusto. This court have duly taken note of the order dated 26/3/2019, wherein the reason why the learned court of the Munsif, North Salmara of Bhayapuri, had rejected the application is on the ground that it would cause delay in disposal of the suit. However, the most pertinent question which ought to have been addressed by the learned court was as to whether the evidence on record was sufficient for the purpose of coming to the conclusion, or was there a necessity for issuance of a commissioner in terms with Order 26, Rule 9 of the Code, more particularly when there is a dispute as regards the boundary. This having not been done so, it is the opinion of this court that the impugn of order dated 26/9/2019 suffers from error in exercise of jurisdiction. Accordingly, this court therefore interferes with the order dated 26/3/2019 and further directs the learned court of the Munsif, North Salmara, Bhayapuri, that is the learned trial court, to issue a commission, thereby directing the circle officer, Boitamari Revenue Circle, to carry out a survey as to whether there is any encroachment over the land as alleged by the plaintiff. It is seen that by an order dated 29/4/2019, the further proceedings of title suit number 35 of 2014 was stayed, the said stay order stands vacated, and the parties herein who are duly appearing are directed to appear before the learned court of the Munsif, North Salmara of Bhayapuri on 14th of July 2025 for further proceedings of the suit.
Item 4 and 5.
It is your honor. No, this is the transfer petition. Where the matter has been amicably settled between both the parties, between husband and wife. It's a matrimonial, so we would like to withdraw the matter.
Miss so-and-so, are you out there in the case?
People cause this,
Are you
I need-
there in the, have you signed the wakalat number?
yes, your
Okay.
lordship.
Miss so-and-so submits that the matters have been amicably settled, comma, she has instructions to withdraw both the transfer petitions. Pusto. Accordingly, the transfer petition stands closed on withdrawal. Full stop. Interim orders so passed earlier stands vacated. Full stop. The proceedings in title suit number D, case number 47/2021, pending before the court of the learned district judge Udalguri stands is that shall proceed shall proceed accordingly. Why there are two orders? Are here? এটাত এইটো দিব, এটাত হল সেইটো দিব, আৰু ইটোত দিব proceedings in Nizzi case number 2/2022 pending before the court of the learned district judge shall proceed accordingly. Parties are directed to appear before the said court on 21st of July 2025 for further consideration.
6,
দুইটাৰে বেলেগ বেলেগ আছে দেই, দুইটা বেলেগ order.
May it please, your lordship.
Yes, what is this?
Your lordship,
Not
yes,
tenant?
yes, landlord-tenant.
What is there?
Your lordship.
How many landlords you are, tenants you are filing?
I am the landlord.
Oh, fantastic. What a good cause.
Your
Now
lordship,
tell me.
Both the courts below rejected my suit on the ground that due date was not ascertained.
Huh?
Due date was not ascertained. However, the courts below did not take into account the plain WS and evidences of both the parties, wherein it has been specifically admitted that the defendant used to pay the rent starting from October and which used to end in the next year in the month of September, that is before Durga Puja. So considering that into account, the rent should have been due on 30th of September because
Where
this
is your
was
plaint?
my plaint
Suit
is
for eviction.
page 13. Now, page 13, paragraph 5, I'll read your lordship. During the first part of January 2014, the plaintiff has decided to construct, no, before that, para 4, that expiry of the time of the tenancy, the plaintiff requested the defendant number 1 in the first part of January 2007, either to enhance the rate of monthly rent or to quit the tenancy. But the defendant number 1 neither enhance the rate of monthly.
Bona
rent.
fide? Bona fide requirement?
Bona fide we have already waived because earlier we took the point that my unemployed son required the premises. But later we accepted that he died.
Who died?
The son.
died.
So now you may have,
But that,
there is a judgment of the Supreme Court
yes.
which says the bona fide till the culmination of the proceedings, it may keep on changing.
Consider.
No, I will, provided an additional affidavit you file it.
This due date also, this will also.
Forget about due date. Why should they do? There is a concurrent finding of fact. I have difficulty. So go on that. There is a judgment of Justice Krishna Iyer on this point, on the question of bona fide requirement. And it says that it keeps on changing. And it is there till the final year. You may waive it then because of your son, because you have a paragraph say, also
Paragraph.
required the tenanted room bona fide for employment if is unemployed soon after the reconstruction of Iman and Iman. The plaintiff is an old man and priest by profession, having no regular source to maintain his family and one employer in his sons, and unless the plaintiff could provide employment by his son by opening a business, the entire family. And why did you wait? When did your son die?
During the pendency, your lordship.
And how much are they paying?
They are paying about 300 per month.
My goodness, where is it? Recently, there is one judgment which has come to my eyes. Yes, very important. Where is that place?
Bongaigaon.
Bongaigaon.
Bongaigaon where?
Bongaigaon. Mm,
Actually, half wall iman on
Hakari
a plot
Vita
of land
near
measuring
City
so and
Village.
so, tenanted room is so and so.
Para 5, they've admitted in their WS at page 20.
What do they say?
That the contents in para number 1 of the plaintiff partly admitted the facts that the tenant paid 300 only per month from last 12 years is false. It is submitted that since the commencement of the tenancy under the plaintiff, the rent of the state room originally was fixed at 150, including the electricity maintenance and 87, but gradually it has been enhanced to 300 only per month till date, excluding the electricity maintenance. Hence, as claimed by the plaintiff that the defendant paid 300 from last 12 years is denied. Your Lordship, para 12 also.
Okay, now till date so and so. Now tell me one thing. Sorry, here they admit. Paragraph number 8.
Paragraph 8, yes.
Why do we have to go into the other aspect of due date when it is an admitted fact? Well, over.
Initially, my lord, it was monthly. Thereafter, it was
Then it
changed
was
to yearly,
converted
my lord.
to
7 days.
Para 8, 9 and para 12. My lord.
This
Para
is,
9.
how did you prove it?
They have also admitted, my lord, that they
What?
used to collect the rent annually.
Huh?
They used to collect the rent annually. The
That
year
is
started from the month of October and it ended in the next year,
September.
September. And there is admission that they used to collect the month annually, sometimes in the month of September, sometimes in the month of October and December also. So that's why the court held, both the courts held that there is no due date, my lord. As per their own convenience, they used to collect, my lord, annually, sometimes September, sometimes.
Duty is you.
They used to come to collect, my lord. Para 9, my lord.
Where?
Your Lordship will find, in fact, they have come to pay the rent. At the end of the paragraph 9, as the plaintiff is a priest by profession and organizes Durga Puja every
Plaintiff
year,
requires the defendant to pay the rent amount in the month of October to meet financial needs, and hence the plaintiff defendants with due courtesy obeyed the decision of the heir for which the defendant deposited the rent amount in the
in
month
the
of.
month of October every year.
Where? Where did you deposit?
My lord may kindly come to para 12, that the contents in paragraph number 6 and 12 are now, it is submitted that the defendants never defaulted yet. It is also submitted that since few years the plaintiff received the rent amount at yearly basis, for which it was decided between both the parties that the year should start from the month of October of the preceding year to the month of September of the present year, and the practice had been carried out by both the parties since last decade approximately. And subsequently for the year 2013-14, the defendants approached the plaintiff on 2nd September 2014 to deposit the rent amount of rupees 3,600 only per month. But the plaintiff did not receive the rent amount and said that he will collect it after the Kali Puja, that is after 23rd October 2014. And when after Kali Puja, the defendants approached the opposite party to deposit the rent amount, then the opposite party again refused to receive it and then conveyed to the defendants that the plaintiff will collect it after Rash Purnima, that is after 6 November 2014. Subsequently, after Rash Purnima on 7th November, when the defendants again approached the petition in presence of witness for depositing the yearly rent, the plaintiff straightly denied to receive the same and the said defendants to enhance the rent amount at an abnormal rate of rupees 1,000 only per month, and as such the defendants are running a flourishing business. The defendants agreed to enhance the rent amount, adding rupees 350 only more to the present amount, which stands at rupees 650 only per month. But the plaintiffs still did not agree with the amount. Later,
When did you deposit in before in the court?
my lord, I had deposit in the, I have filed Miss in the case.
21/11/2014.
Ah,
21/11.
enough. That is
And my
enough.
lord, if my lord comes to page number 41, my lord.
Heights. Enough is enough.
Page number, just my lord, page number 41. This
Enough.
admission on their part, my lord.
Not let the Supreme Court do it. I am not going to touch this. I am going to interfere on this finding.
Page 41, just one line. ma'am.
No, first of all, you say that you have paid it. They may say that, okay, we have accepted it to that effect for 1 year. But then you should have paid it in the month of December, October, you have failed to pay. Then why didn't you deposit till the month of November?
My lord, they kindly come to page 41, my lord. There is admission on their part that they used to collect in September also, October, November, any month, my lord. That's why. There's an admission on their part. PW1 specifically for page 41. ma'am. The plaintiff who adduced evidence as PW1 has stated that the defendant since the year 19 is to give rent to the father and also specific mode of payment of rent to the father. PW1 has also admitted that there was no tenancy agreement with the defendants. Further, he admitted that there was no uniformity in the payment of rent, and so the rent was paid sometime monthly and sometime quarterly. And thereafter, defendant had started paying the rent to him yearly, but he could not say since when they are paying the rent to him.
You are paying now 300 depositing.
650, I think.
Huh?
650, I think.
Now, how did it increase?
Check the records, still 300 is being paid, 3,600 yearly.
Pay 6,000?
6,000 with this.
6,000? Pay 6,000. Bongaigaon. Good place. You've been carrying on the business for long. What business are you carrying?
I think clothes business.
My goodness. Chinese? Chinese clothes. Then?
Maybe
Recognize. Let's see how does the trial court teach.
The lordship may once come to page 28.
This is the fault of how
Trial court had already ascertained the due date also, but thereafter also, the trial court rejected saying.
where's
that,
the trial court judge?
At page 28, the relevant question,
24 it starts.
24 it starts, 28 towards the end, last two paras. From the evidence of both the sides, it is not clear whether the defendants really vacated the scheduled premises and thereby bringing the tenancy to an end. Hence, it can be presumed that the tenancy continued after 31/3/14. Now, what needs to be seen is whether the defendants have defaulted the payment of rent when the rent for the period 2013-14 fell due, which is in the month of October 2014. So once it has-
Page?
page 29, 28, 29.
Hence it can be presumed that the tenancy continued after a month.
Now, what
Now
needs
what?
to be seen is whether the defendants have defaulted the payment of rent when the rent for the period 13-14 fell due, which is in the month of October 14. So it has already been ascertained.
There was no fixed date here, not fixing this particular tenancy.
Regarding the fixed date also, the learned Munshif has confused the tenancy with the monthly tenancy.
Huh?
Because the tenancy period that has been confused with the period.
No. One thing very specific. He is a monthly tenant.
Earlier, he was a monthly tenant.
See, the landlord may accept it later on. That's for his convenience. But it is his duty to pay regularly, monthly. If he fails to pay, forget about the other things. He has failed. The day when you become strict, he is otherwise a monthly tenant, not a yearly tenant. Yearly tenant concept is not there. Then if yearly tenant, can there be a yearly tenant as per the Assam Urban Area Rent Control Act? It has to be a monthly tenant. And if it is a monthly tenant, you are to pay. The tenant has to pay. Now the question is, if the landlord is otherwise not, it may be in very good terms, okay, whatever may be, we are not in a position, we don't mind. But when the landlord gets strict, you are at fault. Third, Mr. S. Dotto, the learned counsel appearing on behalf of the petitioner. Mr. A. Iqbal, the learned counsel appearing on behalf of the respondent. You do one thing. You file an affidavit. Pick up next.
In terms of that division.
The sixth question. I'll give you two grounds. One is that and the other is this. And then begin. We cannot have 300 rupees. My goodness, what is wrong with these people? With this matter again on 23rd of June 2025. For admission.
Obliged.
Deeply aware.
Item 7.
Hmm.
Most of the parties have instructed us that they are sitting for an amicable settlement.
Oh,
All the parties, they provided me.
let us dismiss it then.
My lordship.
What is the challenge?
The condonation order we have challenged, order dated 3/10/2024. The submission is that the executed had all the knowledge because prior litigations are also pending.
Are you challenging this order? You dismiss it. You're lucky to get 3,000 rupees. Where is the time period for will? Isn't he an executor? Rightly or wrongly, he's an executor. And isn't it a noble duty? The Supreme Court says that an executor is a noble duty. He's only performing his noble functions to the effect that it is not therefore his right to sue, right to apply accrues when he feels. It is not 3 years. The law is well settled. What case you have? This 3,000 rupees, I think we should interfere. And if you have taken that,
We have not taken.
okay, we should direct the court to return that 3,000 to him. Because this is absolutely, where is the question of condonation? There's no concept of condonation in a proceedings for filing and seeking a probate. Here he is asking for a probate and filing a Section 5 application. And our court out here has taken it as a Section 5. Where is the Section 5 arises? Law is very clear, not the 1, 2, 5 judgments, isn't it, Mr. Chakraborty? Isn't the law very clear as regards the probating of a will? There's no limitation. There's no limitation. Article 137 says the 3 years from the date on which the right to apply accrues. And in his case, the right to apply accrues when? Of a will, because it is in noble function whenever he feels like. This is what the Supreme Court says. Withdraw, dismiss, cost, which one? Withdraw, better off. The learned counsel appearing on behalf of the petitioner submits that taking into account the settled position of law that in respect to a will, Article 137 of the Schedule to the Limitation Act 1963 duly applies, and seeking probate of a will is a noble duty of the executor, comma, he would not like to press the instant petition. In that view of the matter, the instant proceeding stands closed on withdrawal. Whether there is a stay. Therefore,
Item 8.
This matter, I crave for 2 weeks time, my lord. My client wants to, my lord, have discussed with the landlord. He has got 3, my lord, 2 godrons and 1 shop. So he wanted to surrender 1 godron and he wanted to have some discussion, my lord. It may be fixed, my lord, before vacation any day, my lord.
after taking 2 days of rest, I was feeling very fresh to
All talks has
dismiss.
failed, my lord. He is occupying 5 suit premises in the fancy market. And out of 5, 3 has been decreed on the concurrent pending.
Oh, I remember this matter that
This
day
matter, my lord, he
when she
submitted, my lord.
appeared. So I asked, let me dismiss it in the hands of Mr. Sahewala.
But due to fault of some, my
I have
lord,
only instruction, my
also,
lord. As of now, I have only instruction on the last occasion, your lordship has made the opinion that within 6 months, if you come with the instruction, in that case, I can only concede for 9 months.
Huh?
I can concede for 9 months.
9 months? I'm giving you only 6 months.
Yes, then it is up to your lordship. Because no question of discussion is remain alive.
So one tenant should go. Today I failed to oust one tenant.
Your lordship may pass that, my lord, after 2 weeks, my lord. That order.
Which one?
This special order.
Then I won't grant you that thing. I won't grant you that 6 months then. You want it now, dear? Because CAV, if I do it and do it after 2 weeks, I'll only do it CAV and pass the order on that day. Although I'll dictate it right away, you get that order signed on that 2 days, after 2 weeks. Which one?
Your lordship may pass that. 9 months, my lord, friend is saying.
You want 9 months.
Only on that ground that of for talk. Talk has already failed. Only my of the instruction in case court grants some time.
Chalo. Heard Mr. G. N. Sahewala, the learned counsel appearing on behalf of the petitioner. Mr. So who appears on behalf of the respondent. The revisional jurisdiction under section 115 of the Code of Civil Procedure 1908 have been invoked to challenge the judgment and order dated 5/8/2024 passed by the learned civil judge, senior division, civil judge, senior division, number 1, Kamrup Metro,
Metro.
at Guwahati in title appeal number 19/2017, whereby the judgment and decree dated 15/5/2019 passed by the learned Munsif number 4, Kamrup Metro at Guwahati in title suit number 468/2012 was upheld. Etia itu civil judge to appellate court or it. তাৰপিছত paragraph number 234 হে কিটা আহি যাব। তাৰপিছত For the purpose of ascertaining the dispute which has led to the filing of the instant proceedings and as to whether a case for exercise of the revisional jurisdiction is made out, comma, this court finds it relevant to take note of the brief facts which led to the filing of the instant proceedings. Full. The respondent herein, as for the sake of convenience, the parties herein are referred to in the same status as they stood before the learned trial court. Next. The respondent herein as plaintiff is a Hindu undivided family consisting of its members, number 1, Sri Raj Kumar Agarwal, number 2, Srimati Usha Devi Agarwal, number 3, Gaurav Kumar Agarwal, comma, the last one, the last member being the Kata. Full. The plaintiff is the owner of various shop premises of Narayani block of RCC building known as Maliram Lohia Market, having its principal place of business at Maliram Lohia Market, HB Road, Fancy Bazaar, Guwahati, 781001, Assam. Full. The defendant, the petitioner herein, who was the defendant, took on rent the shop room marked as number 11 at the ground floor of Maliram Lohia Market and was running his business therefrom under the name and style of gift shop as his proprietorial concern. Full stop. The said premises, the suit premises have been specifically described in Schedule C to the plaint. The tenancy initially started with effect from 1/6/1997 at a monthly rent of rupees 935 to be paid within the 7th date of every current month against receipt. Full stop. It didn't start with 1/6. Started earlier, maybe.
It was started earlier, but it was renewed on 1/6/97 by filing executing the agreement declaration in the form of declaration.
The tenancy started earlier. Huh? Good stuff. Be that as it may, on 1/8/1997, the tenancy was renewed up to August 2000. And the rent was to be increased automatically by 15% over the aforesaid rent on completion of every 3 years as per the own declaration made by the defendant. What is wrong with these people? এখন এনেকে নিলিখিলো এই ওপৰত এইকেইটাৰ নামটো লিখি দিছো ন এইটো আনিলো শিডিউল চি বুলি লিখিলো তাৰপিছত দেখো Schedule C, full stop. On 1/6/1997, the defendant signed a declaration containing the usual terms and conditions of the tenancy. The rent was initially agreed at rupees 935 per month, payable within the 7th of every currency month against receipt. The said tenancy was renewed on 1/8/1997, fixing the rent above payable up to August 2000. After that, the rent was to be increased automatically by 15% over the rent above, over the rent on completion of every 3 years. Accordingly, the rent increased by 15%, becoming 1645 from August 2009 to July 2012. After that, the rent increased at the rate of rupees 1891 after August 2012, and the rent was payable by the after August 2012. Full stop. In addition to that, it was alleged by the plaintiff that the defendant was also liable to pay the electric charges as per the meter reading of the submeter installed separately, and the electric charges, service charges of rupees 10 per month. Full stop. It was the allegation made by the plaintiff that the defendant had paid the rent up to June 2011, but stopped paying the monthly rent from July 2011. Further, the defendant also failed to pay the electric and service charges from September 2011 onwards. It is under such circumstances the plaintiff instituted the suit. When?
October 2012.
In the month of October 2012, seeking ejectment of the defendant from the suit premises, semicolon, for recovery of area rent to the tune of rupees 27,058, semicolon, the bracket of the details so given in Schedule A to the plaint. Along with mean profit from November 2012 till actual eviction of the defendant, semicolon, for areas for decree for areas of electric and electric service charges amounting to rupees 7,307, details of which have been given in Schedule B to the plaint. The defendant filed a written statement raising various preliminary issues. Full stop. There is no denial to the fact that the rent of the suit premises was initially at rupees 935, which from time to time increased and was rupees 1891 from the month of August 2012. As regards the allegation of non-payment of rent, it was stated in paragraph number 12 of the application of the written statement that and it was stated, the defendant denied that the rent for the month of June it was denied that the rent up to the month of June 2011 was only paid. It was also denied that the defendant did not make any payments since July 2011, as well as there was no, full stop. The defendant also denied that there was no payment of electric charges since 26/9/2011. It was further stated in the written statement that the defendant has altogether 5 tenanted premises, that is shop number 10, 11 on the ground floor, room number 3, 4, 6 on the first floor in the Maliram Lohia market in different names under different arrangements of payment of rent. But the rent of all the tenanted premises were used to be realized by one Rajkumar Agarwal from MS Gift Shop in shop number 11 since the very beginning. Full stop. It was categorically stated that Sri Rajkumar Agarwal had realized the advance rent from 1st of July 2011 to 31st of December 2012 from all the 5 shops rooms amounting to rupees 1,35,150 and the estimated electric consumption charges till then amounting to rupees 29,450 from the defendant. On the basis of the pleadings, the learned trial court framed as many as 8 issues, which being relevant are reproduced herein under page 37. On behalf of the plaintiff, Sri Rajkumar Agarwal was the sole witness and he had exhibited various documents. On behalf of the defendant, there was no evidence adduced, nor any exhibit, no evidence adduced. The learned trial court while its judgment and decree dated 18/5/2015 decreed the suit in favor of the plaintiff and further held that the plaintiff was entitled to rent of the suit premises since January 2012 till eviction of the defendant. Other reliefs have not been given, na? Area
Has been given, my lord.
not given. Suit is decreed partly. The plaintiff is entitled to the decree of eviction from the supreme. He is further entitled to the rent of the supreme since a month till eviction.
January 13.
Huh?
It's from January 13.
So area is not given.
Appellate court has given.
First. The learned trial court, while decreeing the suit in favor of the plaintiff, held that the defendant was a defaulter in payment of monthly rent. And came to a finding that the defendant was a defaulter since January 2013 and not from July 2013. Full stop. It is very pertinent to mention that the findings so arrived at by the learned trial court was on the basis that the plaintiff failed to prove that the defendant was a defaulter in payment of the rent since July 2011, which in the opinion of this court was an incorrect approach taken by the learned trial court, in as much as the burden is always upon the tenant to prove that he is not the defaulter. Full stop. Be it as it may, the defendant filed an appeal, which was before the court, before the first appellate court, which was registered and numbered as title appeal number 19/2017. Full stop. The learned first appellate court after discussing the grounds of objection so taken, the submissions so made, the evidence adduced, the issues framed, decided the appeal, issues framed, as well as by formulating three points for determination, dismiss the said appeal. It is, however, relevant to take note of that the learned first appellate court, while deciding the said appeal, the learned first appellate court categorically came to an opinion that the defendant, having failed to prove that he had tendered rent since July 2011 came to a categorical opinion that the defendant was a defaulter and accordingly liable to and accordingly upheld the judgment and decree passed by the learned trial court. Full stop. It is under such premises the present proceedings have been filed. This court had heard Mr. S. G. N. Sahewala, the learned senior counsel, assisted by Ms. S. Todi and Mr. So-and-so, who appears on behalf of petitioner and respondent. Full stop. This court, full stop. From the findings of facts so arrived at by both the courts below, it is apparent. Now, from the materials on record, it is apparent that the defendant herein did not adduce any evidence in respect to the pleadings that there was payment of rupees 1,35,000 as 1 lakh. 1,35,150 as the rent from the month of 1st of July 2011 up to 31st of December 2012 as alleged in the written statement. Full stop. It is further seen that there is no evidence led that the defendant had paid the consumption charges to the amount of rupees 29,450, the findings of facts so arrived at by the learned first appellate court and the adjudication so made and the manner in which the learned first appellate court had decided the issues number 4, 5, 6, and 7 in the opinion of this court is in consonance with the well-settled principles of law. Full stop. Consequently, this court is not inclined to interfere with the impugned judgment and order dated judgment and decree passed by the learned first appellate court dated 5/8/2024 entitled Appeal number 19/2017, whereby the judgment and decree passed by the learned trial court dated 15/5/2015 in title suit number 468/2012 was upheld. Consequently, the appeal stands dismissed. Petitioner stands dismissed. You want that 6 months?
My lord,
6 months.
9 months, my lord, my learned friend.
9 months you have arrangement,
my lord.
whatever you do,
Learned-
but
My learned friend
I
complete,
give
my lord.
6 months. I need 6 months. You do whatever outside arrangement, how you agree. এইটো বাকিখিনি সেইখিনি undertaking গোটেইখন দি দিব 6 months. That undertaking, you must have seen those undertakings. এইটো এটা কৰি দিব, এয়া এটা কৰি 9 months কৰি দিব, submits 9 months, 1 year, একেতে 1 year and he says that he is agreeable for 9 months. Accordingly, 9 months মানে within আজি কি তাৰিখ? 11. By 25th, he will submit his undertaking before the trial court. And if it is not there, he can go ahead with the execution. And he will vacate by 11, 1, 2, 3, 4, 6. 11th March. He'll vacate by 11th March 2020. Of course, 30,000.
Lordship, in this case, my lord, as per instruction of my client, my lord, I have handed over the brief, my lord, and I want to withdraw my Ophalac now, my lord.
What?
Brief has already handed over to the brief now, my lord, and I want to withdraw my Ophalac now.
What is it challenging?
Where is my?
Page
Seven
number
ten.
79. Page number 79.
Page number?
Page number 81 is the implement.
Is the stage of the suit?
For evidence, for plaintiff evidence.
There are three petitions.
Three petitions.
What are the petitions? One
One
is
is-
for
One is under order
11 rule 1.
11 rule 12. One is under 11 rule 4 and one is leave to file 11 rule 12. One is a leave petition.
Leave.
Leave.
Show me
Because
those
they-
petitions.
Another, my lord, is the order 7 rule 11 is there now. It's not filed on 2020.
Page 76 is the leave petition. 76.
One is this petition. Why do you need a leave?
They have filed.
No, no, understood. Why do you need a leave?
If not required.
This should have been allowed. You don't require a leave. One. You have to give order 11 rule 1 stipulates interrogatories. When you give it in appendix C in a particular form, giving him asking him to provide that answers within a particular period of time. That is between the plaintiff and the defendant outside the court, and which shall be routed through the court. You can ask for that. And the court only comes into action when he does not give, and then the court can be called into to take action under order 11 rule 20. Isn't it?
Yes. Trial court, if during the stage of
So
evidence-
so the question does not come out here. Where is that requirement? These interrogatories could have been very well answered.
So the trial court held that since it is at the stage of evidence, so could not go into that stage.
So you have a stage where you can go for interrogatories
No,
in a suit?
The trial court held that.
No, I'm asking you.
Okay, it can be.
This should have been allowed. Because these are various important things. Order 11, no, normally the trial court lawyers, they do not engage in this. In fact, this is one of the most helpful things. And then it really is helpful at the time of cross-examination or adducing of evidence once you get these replied.
But my lord, they have asked lot of questions. 21 numbers of questions.
You answer, you don't answer, then that is your lookout. What is the second one?
Second one is order 11, rule 4.
Rule 4. Interrogatory.
This is one and the same. And what is third one?
Third one is the leave. Third one is the leave. Leave application.
Where is it? Ubri. Order 11 rule 4 is in the form.
Form. Appendix.
So one was the interrogatories.
Interrogatory.
Second was the
The first one is, my lord, discovering discovery, my lord. Order 11, rule 12, my lord.
rule.
12, my lord. First one is,
This is for discovery.
my lord. Second one is interrogatory. The third one is leave.
Third one is
Leave, my lord.
Leave.
leave.
To accept the interrogatory.
He has not adduced his evidence.
But I'm the plaintiff. I'm yet to adduce my.
So this is by the
by the
defendant.
defendant.
I think we should allow the petition.
Okay, so far the order 11 rule 12 is concerned. Here there is a provision. If satisfied that such discovery is not necessary.
On hearing of such application, the court may either refuse or adjourn the same if satisfied that such discovery is not necessary or not necessary at that stage, the suit or make such either genuinely or limited to certain classes. But the court has not exercised the
The
discretion.
power that, so far this, my lord, the court did not. Court said that
No, why the court have refused the leave? Merely because the suit has gone to this
stage
stage.
of evidence.
But does it say in this case that it has to be before the evidence. Because if you see order 11 rule 14 also,
Production of document.
anytime,
Yes. Anytime. during the period.
I think what is required to be done is directing order 7, what does order 7 rule 11, how does it come into the picture?
They have filed a petition.
In the year 2021, my lord.
Oh, that is rejected. That should be rejected. And the other two, you are not challenging the order 7 rule 11. You are challenging that. The rejection of the order 7 rule 11.
There's only one order, my lord. In this order, my lord, on a single order, my lord. They have passed all 3 petition and another which is pending since 2020.
Are you challenging the order 7 rule 11?
Yes, that is in this order, my lord.
Order 7 rule 11, you cannot challenge it here.
That is why,
227.
my lord. Order 7 rule 1, in a single order, they have passed this order.
Maybe
Proceed,
there are one judgment,
proceed.
a counterclaim is being decided. Just for example, he
It is a
files a
reasonable
suit,
order, my lord.
he files a suit for not to remove him without due process. The
Okay.
other side, or asking for something, the other side files a eviction suit
Okay.
as landlord-tenant, and he files a suit for specific performance. Then in that case, his suit is dismissed, and the counterclaim is decreed. Are you saying that only one case will come? No, there has to be 2 proceedings. But you have not challenged the order 7 rule because you have not done, you have moved under 115,
No, my lord, 227.
227 to it won't lie. Because here, against the order of these 3, you are not challenging the other one. Kindly see your petition.
Yes.
He has not challenged the order 7 rule 11. So order 7 rule 11 remains as it is.
In fact,
So I think these 3 petitions, the court should grant the leave for interrogatories. And as regards the document, order 7, or we direct the court, let the leave be granted for the interrogatories.
and court may decide whether it should be allowed or not.
Which one?
This interrogatories.
The interrogatories should be allowed. But as regards application for discovery of documents, let us see that application. Where is that? This
Page number
person has also
59.
written it so long, so small petition. What is the document?
Page number 64.
For the appreciation.
10 numbers of document they have got.
What is the problem with judge? What is the discovery is asking, that in case of what documents is he asking for?
Page number 64, ma'am. 10 numbers of document.
Page
64.
64. Either original or certified copies of both the land records regarding so and so, then original ownership and showing proving possession over so and so. We do one thing. We interfere with this order and thereby say that the court should grant the leave in respect to the interrogator and take a decision as regards
This
these
document.
documents, whether it is necessary. This is what you want. Your client wanted. Your name?
A Mubarak. A Mubarak.
A.
Mubarak.
Mubarak, the learned counsel appearing on behalf of the petitioner, Mr. G. Bhardwaj, the learned counsel appearing on behalf of the respondents. The supervisory jurisdiction of this court have been invoked, challenging the order dated 7/10/2023, passed in title suit number 17/2019 by the Court of the Civil Judge Junior Division Number 1, Dhubri, hereinafter referred to as the Learned Trial Court, whereby the petition numbers 3475/23, 35727/23, and 3532/23 were rejected. First, the learned counsel appearing on behalf of the petitioner at the outset submitted that there is no challenge to the rejection in the present proceedings to the order dated 7/10/2023 insofar as rejecting the petition number 86/21, whereby the defendants had sought rejection of the plaint. This court was under such circumstances, the question which arises before this court as to is whether the learned trial court was justified in rejecting the petition numbers 3475/23, 3527/23, and 3532/23 on the ground that the suit had proceeded to the stage of filing of evidence of the plaintiff. It is relevant to take note of the provision of the provisions contained in Order 11 of the Code of Civil Procedure 1908, for short, the code, are is a very are an important the provisions of Order 11 of the code relates to interrogatories and inspection. Relates to interrogatories, discovery and inspection. This provision aids in an early culmination. Aims at arriving at the truth of the, arriving at the root of the matter, arriving and aims at arriving at the arriving at to ascertaining the truth in the litigation, which is a what star? Maria, what does it say?
Maria, yes.
There's a word used by the Supreme Court. Maria. Maria, they say there's a
32 to 40.
Maria, they have dealt with this provision.
Yes.
discovery, inspection, and production of documents. These provisions contained in Order 11, read with Section 30 of the CPC, helps in ascertaining the truth. And the Supreme Court, in the case of Maria Margarita Sicura Fernandez versus Erasmo Jack Sicura, reported in 2012 5 SCC 370, observed that these provisions ought to be frequently used by the judicial officers for ascertaining the truth. First, it is seen that the petition numbers three five three two and 3532/23 pertains to seeking leave in terms with Order 11, Rule 1. And petition number 3527/23, where the list of interrogatories so submitted. Taking into account that the answers to the interrogatories not only would aid in ascertaining the truth of the matter, but would also result in reducing the length, reducing the it would lead to an early culmination of the dispute, comma. The leave so sought for in terms with Order 11, Rule 1 is required to be liberally allowed. First. However, it is noted that the learned trial court did not allow the leave merely on the ground that the issues have been framed and the trial had started. It is relevant to take note of that the evidence is yet to be adduced. And as such, the hearing of the suit had not started on the date on which the applications were filed and the impugned order was passed. Under such circumstances, it is the opinion of the court that the learned trial court ought to have granted the leave, thereby allowing the petition number 3532/23 and directed and proceeded with the and and allowed the defendants, the plaintiff, to answer the interrogatories as raised in the petition number 3527/23. The learned trial court, having not done so, in the opinion of this court, committed an error in exercise of jurisdiction. Number two. Let this court now take into account the petition number 3475/23, which is a petition filed under Order 21, under Order 11, Rule 12 of the Code for discovery of documents. Full stop. It is seen from a perusal of the said application that as many as 10 documents, discovery of 10 documents was sought for. Full stop. This court further finds it relevant to take note of the provision of Order 11, Rule 12, which stipulates that the learned trial court has the power to either refuse or adjourn the same, refuse, if satisfied that such discovery is not necessary or not necessary at the stage of the suit. However, it is seen that the learned trial court did not exercise its jurisdiction, but the learned trial court had rejected the petition only on the ground that the suit had proceeded to the stage of trial. This again appears to be an error in exercise of jurisdiction. Consequently, this court therefore disposes of the instant petition with the following observations and directions. This court grants the leave in terms with the petition number 3532/23. First. Number two, this court further directs the learned trial court further grants the leave to the applicant, to the petitioner, who are the defendants in the suit. Petitioner, who are the defendants in the suit.
Defendant number one.
Defendant number one in the suit, to submit those interrogatories to the plaintiff. Next, first, the plaintiff is granted the liberty, if so advised, to take recourse to Rule 6 and Rule 7 of Order 11, if so advised, Full stop. However, if no such steps are taken, within the time stipulated in the said rules from the date fixed for appearance of the parties by this court hereinafter, comma, the defendant, the plaintiff shall have to answer to the interrogatories in a manner provided under Order 11. Number 3. This court, taking into account that the learned trial court did not exercise its jurisdiction in respect to the petition number 3475/2023 in the manner provided under Order 11 Rule 12, directs the learned trial court to hear the said application, being petition number 3475/2023 afresh, and decide as to whether the discovery of the documents so mentioned in the said petition ought to be allowed or not within the purview of Order 11 Rule 12 of the Code. Full stop. It is seen that further proceedings of title suit number 17/2019 was stayed by this court. Next, by the order dated 12/6/2024. Said order stands vacated and parties herein are directed to appear before the learned trial court on 21st of July 2025. Full stop. The period in terms with Order 6, Rule 7, or Order in terms with Rule 7 and Rule 6 and Rule 7 of Order 11 shall be counted insofar as the plaintiff is concerned with effect from July 28th, 2025. Then from there 7 days.
Item 10.
That you inform, you got a better order without the file. Yes, Mr. R. Chaudhary. Very contested matter, both sides. R. Chaudhary and Ms. PK, Mr. PK. Yes, what are you challenging?
My lord, I'm challenging the page 76 order. My lord, in a partition suit for separation of property, my lord, the petitioner's mother, my lord, died. They died long back, of course. Filed an application for impleadment. It is a partition suit, but that
And the
was
petition
rejected.
for?
Suit for partition suit, my lord. It's a partition of the co-sharers. In fact, it's a suit for separation of the property. That is the. Number, there were altogether 43 defendants, and suit proceeded ex parte against 34, including the mother of the petition. The my lord, the mother resided in a different place. She didn't know, she didn't receive the notice. The trial court, my lord, by passing the input order, said the notice was served to the brother of the. In fact, he is not a brother. My lord, will kindly come to the page 76. Page 76, my lord. I'll take your lordship the relevant part of the finding, my lord. It is at page, my lord, page 78. Page 78. And I'll show your lordship the process service report, which I have annexed. Page 78, lordship got, my lord. Down below, on perusal of the case record, particularly service report dated 7/3/2012, it appears that process server had stated in his report on 5/3/2012, he went to the address mentioned in the summons, and brother of the defendant number 25, 26, and 27 received the summons on behalf of them. My mother was 27. My lord will kindly come to page 55. For a while, I'll read the rest my lord, later. Page 55, my lord. Page
55.
55 is the, page 55 of the petition, my lord. The process service report. Today, on 5/3/12, at about 12 AM, this is a translated one. I have visited the residence of defendant number 25, 26, 27 as per address given in the summons and found them absent. Their own brother, Major, residing in the same extended family is found present. I explained the details of the summons to him, and he furnished his name, signature as above in the report and received total 3 numbers of summons on behalf of them. Defendant number 28 is found present there and explained the details to summons. Therefore, he signed his name and signature and above. Moreover, the witness mentioned are also witness who put in signature. My lord, kindly come to page 17 now. He says defendant number 28 is my brother, placed to page 17, my lord, who is the page 17 of the plaint, my lord. Huh? Page 20 is the relevant part, is the name, my lord. He said the notice is served on defendant number 27. 27, my lord, is my mother. 27 is mother and received by the defendant number 28. So he said he is my brother. The defendant number 27's father's name is late Rahmat Ali Majumdar. And defendant number 28's father's name is Abdul Ali Majumdar. So he is not my brother. Therefore, he received on behalf of all.
Huh?
The defendant number 28 received service as per process server report.
28 is
28 Nizamuddin Majumdar,
Majumdar.
who is son of late Abdul Ali Majumdar.
Then
And my mother's name is Kamala Begum Majumdar, daughter of late Rahmat Ali Majumdar.
and what is the wife's name? Husband's name?
Husband's name is Kamala's husband is different, my lord. It is not.
What
husband
is
name.
your father's name?
My father's name was Rahmat Ali Majumdar.
Huh?
The defendant number 727's father's name is Rahmat Ali Majumdar.
No.
Ghulam
Who has filed this application?
Salam, the son of the defendant number 27.
So therefore, what is your father's name?
Ghulam Ahmed Barbhuiya.
So therefore, he is Ghulam Ahmed Barbhuiya.
He's the husband of defendant number 27.
His wife is Kamala
That's right.
Begum Majumdar.
That's right.
That is what I asked.
That's right. Exactly.
Because if you are the son, your father would be the heir.
That's right. So now it's the
Okay, then-
his son came. Now, my lord, this is the report on the basis of which the Landlord trial court said that notice is served. So no, it is a partition suit. Well, every question should be a party, my lord. After all, it is a partition suit.
What is the stage of the suit?
Suit is, of course, it is the argument at the stage of
Final,
argument.
final arguments.
Argument,
Final arguments.
stage of argument.
So what do you want to do? You want
I
to
want-
delay?
I'll not file any helpful. I have to be impleaded only. I should be there, my lord. I should be impleaded with the party.
You are there.
But that is rejected, my lord.
My
Implead-
goodness, what is wrong? So many judgments have delivered,
That's
people
it,
they
that's
don't
it.
understand.
That's order one, rule 10, no? And order one.
Order,
That's-
they
that's
filed
a-
an order 917. He doesn't want to file a written statement.
No.
He wants to participate. He can participate.
I am also dependent, sir. I am dependent number 1 to 4. He is for plaintiff. He is.
Tell me,
Yes, this title suit was filed way back in in the year 2012.
I am not on that.
No,
No.
someone was
No, Mr. Counsel, answer me a very simple question. Can the court stop him from appearing?
No, cannot.
Now, the second question is, have you substituted?
His mother was, she was ex parte.
So,
Way back in 2012, your lordship.
so,
Way back in 2012, she was granted ex parte.
so he
She
wants
died
to
in
be,
2015.
he has to be, the court knows now. That means against the dead person, if the moment he files this application, the impact is, the court knows that that person had died. Now, what is the impact? Tell me. Ex parte is okay. Ex parte vacating is okay. But the question is, once the court knows, this is on record, that he had died, Kamala Begum Mojumdar had died, then how do you proceed?
She died in the year 2015. Court has considered, Landlord Court has considered it. She died in 2015. Thereafter, after about 6 years, he has made an application that I maybe, when the case has gone to the extent of final argument, your lordship, now he has come with an application that was on the order 1 rule 8A.
Order 1 rule 8A would not come into the picture. They may like, this is where?
When-
Barak Valley?
Yes.
Barak Valley, they like all provisions. Yes. But order 8, but tell me a situation when a court knows now that it is going to pass a decree against the dead person, how do you take care of it? Tell me. It is on record?
Record.
Then
But since it was ex parte, your lordship, therefore,
understood. It is ex parte. Ex parte does not stop him from appearing. Remember that. There is no quarrel with that. Now, he has come out there by filing an order 9 rule 7, being thereby bringing to the notice of the court that look here, my mother died. Forget about order 9 rule 7. But he informs the court that my mother died. Now what does the court do? Give me an answer to that. How do you take care of it? Later on, you will have a big problem, bigger problem with this when you get a decree. You cannot affect against them.
even we have no claim. They are all a pro forma respondent. We don't have any claim against them, your lordship. They were the pro forma defendants.
No. If they are the pro forma defendants, so you have no claim.
Even
Means
he has
are they going to get a share in the property or not?
They have already got their share. He's in the.
Whether in the partition, would they get a share in the property? Let us see what your plaint. Why are these people struck off?
Struck off by the petitioner, your lordship, on the ground that they were pro forma.
Page 22, my lord. Says.
Who
I
are the
was-
main defendants?
Page 17.
Principal
lordship, title
defendants are 1 to 4.
1 to 4. Represented by my friend.
What is your relief claim?
There are two members of the plaint.
For passing a preliminary decree declaring the plaintiff's right, title and interest in respect to schedule with so and so. For passing a decree for preliminary inquiry with direction of partition the share of the land of the plaintiff out of the Sutpatta land of second Iman by meets and bounds and to submit report before the honorable court by preparing Saham. For passing a final degree of heir of share of the plaintiff. Now, what is how do you define the other, say, pro forma defendants' rights? The suit is for preliminary decree regarding declaring the plaintiffs in respect of so and so land and so and so. The grandfather of the plaintiff, number 1 to 4, and the father of the plaintiff, number in his land. Right? Who are the pro forma defendants?
In the title suit.
Huh?
In the title suit, lordship.
Ah,
They were, I think, cousin brothers.
huh?
Cousin brothers of the petitioners. This long family tree brothers. They were brothers in law.
Would they have a right in the partition? I'm only asking you that.
In fact, your lordship, they have already got their matter partitioned and they are having their possession, your lordship. That is also admitted in page 9 of the petition itself, your lordship. It is their plot of land, their possession of land, we have not claimed, your lordship.
You have not mentioned why you are making the performer defendants a party in the suit.
It's there, I think, your lordship.
There is not a single word. Mr. Roy, are you claiming any right over this land?
Yes, the my lord will kindly see page, page 22. My predecessor and his predecessor jointly purchased, page 22, paragraph 2 of the plaint.
Yes, where?
The grandfather of the plaintiff, 1 to 4, father-in-law, and so, and during lifetime, along with Rahman Ali
Along with?
Majumdar. Rahman Ali Majumdar is the father of the defendant number 27.
In page 31, they have mentioned pro forma defendants. After verification.
So, yes, sir.
Your father's name is Rahman Ali Mujumdar is?
The father of the defendant number Kamala Begum.
Okay, so you jointly purchased.
Lordship.
Then
Page 31. Oh, they themselves said, my lord, page 31.
yes.
About pro forma, after verification, NV, the pro forma
In
defendants have been made
parties-
parties in the suit as the pro forma defendants are co-sharers.
In the suit,
Suit
and
patta,
if
and
any
they are
other
one of
offer contest the claim of the plaintiff in that case, such contest to be treated as principal and all reliefs paid against themselves here. So therefore, the question is, if they have any right, your decree will become nullity?
Time during execution, they may come, your lordship, that because we are not claiming.
No. The question is the court knows. The moment they file an appeal tomorrow, if you don't allow him, they file an appeal. How can you have her against me? Because of the fact that my mother was dead, was duly informed by filing an application under Order 907. He could not have filed an Order 907, taking into account he is not a defendant. So his petition therefore should go. His petition should have been, at best, an Order 1 Rule 10. Order 1 Rule 10. But taking into account his petition is Order 9 Rule 7, one can convert it into Order 22 Rule 4 and implead him in view of more particularly the judgment of Om Prakash and the earlier judgment out there. So if we can substitute him, without substituting him, the question does not arise. But Mr. Counsel, you will have a big problem. If he doesn't want to file the written statement, well and good. But otherwise you have a problem.
My instructions for land friend say that she wants to, she may be allowed to file this. That's it.
Huh?
She may be allowed to file written statement, as in fact, my learned friend says that.
That means you want the suit to go back to that stage.
Possibly, I'm going to. No, my lord, I'll not, I better not file me. I better not file, because at this stage, it's very difficult. After all, after so many years. Yes, it is. Let's say, we don't, go to, at this stage, without WS. Let me be present, my lord, in the suit.
Hmm?
I should be made party, I should be there in the suit. My lord. After all, it's a partition suit, my lord. Every co-sharer should be, my lord. In fact, there is, in the partition suit, there is no defendant, everyone is plaintiff.
But the main problem is that, Mr. Law Scott,
Okay.
how do you take care of that situation? Because this petition is, it appears very simple.
Yes.
Order 9 Rule 7, it's not a simple petition. It goes very deep into, and thereby striking it, saying into the court, well, look here, this person is dead. Now you want to pass a decree against the dead person, and you have not substituted. And that person is there who is going to raise that issue before the court. You know, Mr. Brucasto does. Yes.
2020, at least from 2020. 2020. And I'm a point out, the application of the petitioner. He says that he murdered, that's one kata in dock number 705. And their schedule, he does not say that in schedule 2, wherever the plaintiffs are claiming, within that, whether this one kata is there. Because in 3 boundaries of the schedule 2 is dock number 705, remaining length of dock number 705.
Because his petition is otherwise not maintainable. Mr. Roy, your petition is not maintainable. How can you have an order 9 Rule 7 if you are not a party?
For that, my lord, for that, I come up with a judgment, it's a very too technical thing, lord, the court in a partition suit should be liberal, lord. That's, there's a.
I am not, I will be liberal, but that petition is not before me.
Yeah, my lord, in a partition suit.
Huh?
Supreme Court.
What do you think,
lordship
Mr.
in that
Losko?
even can given liberty to file a proper petition, that can also, after all, it's a partition suit.
There are 2 ways. I may say that his petition is not maintainable. And they say order 9 Rule 7. However, the fact that he is dead, I'll have to mention. Which will definitely, the second option is, this will hit you when the suit is disposed. You will not come in because he's a dead person. So you are getting a decree against the dead person. One of is a dead person. Now the second option is treating order 9 Rule 7, petition is not there. But the fact that he is the son, which you duly acknowledge. So I, applying that judgment, substitute these people and say that he is not going to file the written statement. Would be, and by which it would help you in proceeding with the suit. But when he goes there, you know, in Barak Valley, he will change.
File a WS.
Huh?
You will try to file a WS there. You will try to file a WS there, and then the case will again start from the very beginning. So the High Court has given me that.
Because here Mr. You don't get Mr. Roy there. So here Mr. Roy says that he's not going to file the WS. So he will only participate. So it's okay. So then the matter is over there. We can keep it out there and put it out there and then go for a disposal of the suit. This appears to be much easier for you at the end of the day.
My
You
lord,
will only argue out there.
my lord, though I made a application under order 9 Rule 7 and order 1 Rule 8A, but the prayer, if lordship kindly see, prayer, page 65.
Page?
Page 65.
taking ex parte order.
Prayer is for impleadment.
So therefore, by applying that judgment of the Supreme Court, his application also, a defendant can also file, a legal representative can also come up and ask for that. So he has come, so allow it. And thereby make him a party out there. He is not filing written statement.
That your lordship. That your lordship, if you file, that will consider on merit. The trial court will consider. After all, I cannot consider after all, without my client's instruction.
Huh?
Without my client's instruction, it will not be proper. The lordship will leave it open for to file, then trial court will consider, will file an application for separate application for filing WS and all. The trial court will consider.
It is possible only if it's substituted.
Yeah, after the substitute.
Only if it's substituted, then only this is possible for filing a constitution. Otherwise, Order 9 Rule 7 you can participate in the argument.
Order 9 Rule 7 too doesn't arise.
It's there is so.
Chalo, think over it. We'll take it up at 2. Yes, Mr. Roy.
I'll leave it to your lordship because after all, my lord, the partition, everyone should be there, my lord. And here we have only said that the train schedule was shows a Dag number 705, which is our land. They're claiming, my lord,
You are only claiming one kata
one cut, that's right,
of 705.
70.
How much is there in 705?
Seven bigas.
Huh?
Seven bigger, 13. In two ducks, my lord, seven bigger,
No, 705 has how much?
705, the plain schedule B, no?
7
Page
kata, 12 chatak, 11 gondas.
Hmm.
He wants partition of how much? How much land is your ownership? You are claiming?
3 kata.
Huh?
3 kata.
3 kata, 13 chotas, schedule in Dag number 705, schedule 2.
And another
It is 100 Dag, no? Other Dags I am not concerned, my lord, only 705, schedule 2. One cut.
You are claiming 8 chataks and 9 chataks.
My lord, they are claiming 3 kata, 13 chotaks in Dag number 705.
709.
No,
705, schedule 2.
Because in 9 becomes the allegations that we have in number
It is
1
with
to
them.
1 to 4 as well.
Yes.
no, understood. But the question is, how much is he claiming? What is your right? How much is he claiming?
Page 31, your lordship.
Huh?
Page 31.
Understood. How much are you claiming? Just for final decree,
Oh.
what is your share? A partition of the share of the plaintiff on the basis of the report submitted by the collector. Now, how much are you claiming?
Schedule 2 is claimed.
Schedule 2, your lordship.
Where?
Page 31. 3 kata 13 chatak in Dag number 709 and another 3 kata 15 chatak in Dag number 705. Total 7 kata 12 chatak.
So you are claiming total
7 kata.
7. You are claiming total 3 katha. Total 7 katha, 12 chata, 11 gondas. That is what you are claiming.
Lordship.
How much is the total land in 705?
In schedule 1 it is given. Page number 30.
This is 2 dags.
Yes, 2 dags.
We are concerned with 705. He is only claiming of 1 katha. He's not claiming anything more.
Seven zero five is more than what is given in schedule 2 because you will also find the boundaries. It says remaining land of 705. There are more than. Oh, tag number of page 24, bro. Para 2. Tag number 705 with 6 biga, 16 kata, 13 chotaks.
Yes.
Paragraph 3
Paragraph
at page 24.
No. 6 bighas and entire land of Inman is 4 katha.
4 kata in 709.
No, it can't be. No, this is the total land.
Total land, your lordship, in 705 it is 6 biga, 16 kata, 13 chatak. and entire land of Dag number 709 is 4 kata, and the total land thus comes at 7 bigha, your lordship, comprising both 705 and 709.
So you are claiming out there
Total 7 kata.
7 kotha, 12 shotaks. So their land is already there.
They are in possession of their land. It is also admitted by them. They are in possession of them.
So then in the preliminary, after the preliminary decree is passed, fight it out in the collector's place. There you can very well fight it out.
Your lordship, an observation that we can, after the preliminary decree, before the section 50, we can.
I'll record his submission
Right.
that the plaintiff, the petitioner's 1 kata of land is what the petitioner is not claiming, the plaintiff is
Right.
not claiming. And as such, as they are parties out there, they are party out there, that will be taken up if any preliminary decree is passed. I think otherwise it is only a case of delaying, because your petition is otherwise not maintainable. Heard Mr. P.K. Roy, the learned counsel appearing, senior counsel, assisted by Mr. R. Chaudhary, the learned counsel appearing on behalf of Mr.
MH Loskar.
M.H. Loskar, the learned counsel who appears on behalf of the respondent numbers
1 to 5.
1 to 5. Mr. Yeah, appears on behalf of the respondent numbers 6 to 9, na? 6 to 9. The present application has been filed challenging the order dated 10/5/2024 passed in Mizzi case number 24/2010 arising out of title suit number 16/2012 by the learned, what is that court?
Learned
Court of the Civil Judge Senior Division number 2 at Silchar, hereinafter referred to as the Learned Trial Court, whereby the said miscellaneous application was rejected. It is relevant to take note of that the respondent numbers 1 to 5 in the present proceedings had filed the suit being title suit number 16/2012 before the court of the civil judge number 1 Kachar at Silchar. Subsequent thereto, the said suit was endorsed to the court of the civil judge senior division number 2 at Silchar for disposal. In the said suit, various parties were arraigned, including the mother of the petitioner herein, as the performer defendant number 27. At the outset, Mr. M.H. Loskar, the learned counsel appearing on behalf of the plaintiff, submitted that the plaintiffs have no quarrel with the right of the performer defendant number 27 in respect to 1 kata of land which is in possession, 1 kata of land yet in Dag number 705 of Patta number 321, na?
3 to
321. And as such, he submits that the suit have, and as such, it is submitted by the learned counsel that the suit, in the said suit, the mother of the petitioner was arrayed as a performer defendant number 27. In the backdrop of the above, let this court now consider the case of the petitioner. The suit, being title suit number 16/2012, upon being filed, summons were issued. The record reveals that the summons, upon being duly served, the learned trial court, by an order dated 13/3/2012, decided to proceed ex parte against the performer defendants. First, in the meantime, while the suit was pending, the performer defendant number 27 expired on 19/12/2015. Subsequent thereto, after 5 years, on 31st of October 2019, 31st of October 2019, the petitioner filed an application under Order 1 Rule 8A of the Code of Civil Procedure 1908, for short the code, read with Order 9 Rule 7 and Section 151 of the code, stating inter alia that the service was not properly meted out against the defendant number 27, performer defendant number 27, and she died on 19/12/2015. And under such circumstances, the petitioner be arrayed as be impleaded in the suit, being the legal representative of the performer defendant number 27, by vacating the ex parte proceedings. And further, the petitioner be allowed to file the written statement for proper adjudication of the suit. First, the said application was rejected by the impugned order dated 10/5/2024. And it is under such circumstances the present application has been filed. First, this court have duly taken note of the impugned order dated 10/5/2024. And the reasons so assigned in the opinion of this court are not such which this court feels it necessary to exercise its supervisory jurisdiction. More so, when the plaintiff have duly admitted that the plaintiff has do not claim any right over the 1 kata of land presently in occupation of the defendant, of the petitioner, who is the son of the performer defendant number 27. First, apart from that, it is also relevant to take note of that in the said suit, so filed by the plaintiffs have sought for a preliminary decree initially and thereupon for passing of a final decree. First, it is no longer res intriga. It is well settled that when a preliminary decree is passed, comma, the collector or any officer, any gazetted officer, so deputed by him, or any gazetted subordinate of the collector deputed by him has to carry out the necessary inquiries. Full stop. While making the partition and then submitting the report. Full stop. This court is of the view that in such a situation where if a preliminary decree is passed and a proceedings is initiated before the collector or any gazetted subordinate of the collector deputed by him in that behalf, comma, the petitioners would obviously have a right to make necessary would have a right to place their case before the collector during the period while taking into account the partition. First, considering the above, this court is not interfering with the impugned order. Full stop. The interim order passed on 22/7/2024, by which title suit number 16/2012, pending before the Court of the Civil Judge Senior Division number 2, Kachar at Silchar, was stayed, is hereby vacated, and the parties herein, that is the petitioner, that is the respondent numbers 1 to 5, as well as 6 to 9, who are duly represented, are directed to appear before the court, the learned trial court, on 14th of July 2025 for further proceedings of this. Obliged.
Deeply.
What is this? So many ayahs, what is this?
For substitution, my lord, substitution and condemnation of delay for.
Huh?
There is applications for substitution of respondent and plaintiff. Appellant, and there are some IA for condemnation of delay for substitution. And like what had happened, my learned friend filed an objection the last occasion regarding my lord filing of Wakalatnama.
Wait. Mr. M.A. Sheikh was appearing.
Yes, my lord.
What is this?
Subsequently, we are appearing this one.
What case is this? Delay.
Yes.
640 days.
Right.
For
Filing substitution.
why? Why the delay?
My lord. First one is my lord.
Who is appellant number 1B? 1B must be a brother or sister of 1A.
Yes,
Then why that a 1A does not know that 1B died?
my lord, one B Hazrat Ali was died on my lord 7/6/2022.
Ah.
And there were some, my lord, communication kept between the advocate engaged earlier and with the, my lord, appellant. The appellant number 3 was the person who, my lord, contacted the earlier advocate and, my lord, when he expired, my lord, there is a communication gap between the appellant, other appellants and the counsel engaged.
Who was the earlier counsel?
MS Ekman.
Then?
Paragraph 4 at page 10, my lord, I have explained the delay matter.
How many people died? In the meantime?
My lord,
In the meantime, how many people died?
my lord, in the meantime, Hatimuddin Sheikh, the appellant number 3.
Huh?
Hazrat Ali, my lord, appellant number 1B. And, my lord, defendant number 1. Respondent number 1.
What is your ground of appeal? Substantial question of law.
My lord, I have not prepared on merit today.
No, don't. I don't do that. Don't expect it. Decree for declaring that plaintiff has right, title and possession, interest and possession in respect. Decree declaring that defendant numbers have no right to sell. Decree declaring that by virtue of the sale deed, they have not acquired any title. Declaring that plaintiffs are entitled. Decree declaring decree of permanent restraining their agents from dispossessing the plaintiff from the suit land and from disturbing. So you are in possession.
Yes.
Then?
We are,
You are the plaintiff.
my lord.
Then? If you are the plaintiff, how does the substantial question of law?
So we are plaintiff. We are plaintiff.
Therefore, you don't know. You are the plaintiff or the defendant.
Not at all.
Prepare it properly.
My lord, for the, since my lord substitution.
No.
I have not
I
gone through
will
the appeal, my lord.
Appellant substituted, appeal dismissed. There are many formulas for that. Your case, substantial question of law, therefore I fixed it today at 2 p.m. to finish it off.
I'm sorry, my lord, I did not prepare.
The counsel appearing on behalf of the appellant is not ready, for which the matter stands adjourned to be listed again when?
After a week. Next week, my lord.
Listed next week. Later the picture.
Any day.
Mr. Purkasta,
At
your
2
matter.
PM, Lordship, can be at 2 PM again.
No, we finish it off. Another date that fixed.
Timing item 2.
2 p.m. ko dibe, to শেষ করে দিবে। We'll implement substitute and finish it off.
My lord, I will.
Mr. Purkasta, have you got that thing done? Compromise. You have not filed.
Yes, fine.
When did you file? Huh?
It is not tagged with the record.
No, compromise petition you have filed.
Yes, yes. I
When?
have served the copy to Mr. Sattar.
They say that they have not filed.
No. He has put his signature, copy was served to him. His email. That was filed on 9/6.
Which matter?
Yes, Lord.
Compromise petition filed.
Lordship, yes.
What is that miscase number?
This case, no,
Matter cannot go on for such a long time. I think we should dismiss it. Whatever compromise has happened. Can't help it. We dismiss it. This is appeal is not maintainable. This petition.
it's not a review, appeal.
I am not, when a thing is not maintainable, no compromise. I don't have the jurisdiction for compromise. Go before that court.
My lord,
I don't have the, Mr. Purkasta, tell me one thing. If this court doesn't have the jurisdiction under 227
my lord.
to decide this, be taking into account it is a decree which has been passed.
Oh, but
It
yes,
is a decree, it is a decree because of the fact that it is an order passed under Order 21 Rule 97. And as such, it is a decree and appeal lies there against. How will this court affect the compromise between both of you? Give me a good reason.
my lord, order passed by the executing court. My lord, under application filed under order 21.
That is what, it
That's what
becomes a decree.
Yes, lordship is saying.
And if it is a decree, an appeal lies. Now, I don't have the jurisdiction for that. You do one thing,
My lord,
you withdraw this,
my lord,
go file that application there.
before the court below.
Before that executing court,
Yes.
that is the only way out.
Right. Lordship kindly make an observation.
Because I, because you, Mr. Pukasta, you understand, I
Aye.
don't have the jurisdiction.
My lord, my lord. That's why, my lord, we have lot of things to be learned from this court.
No, nothing. I learn from you every time. But the problem arises because the
Yes,
matter when it went
I
away, na,
understood.
he said a compromise. That day I allowed it. But today when it went away, then I thought that can I allow
Right,
that
right.
compromise?
In
I saw his petition.
2015, when I was lacking knowledge.
Huh?
In 2015, a petition was filed in 2015. At that point in time, I didn't have so much of knowledge, my lord. So perhaps because of lack of knowledge, my lord.
Okay. The learned, heard Mr. A.K. Purkasta, the learned counsel appearing on behalf of the petitioners, and Mr.
W Hook on behalf of case.
appearing on behalf of the respondents. The learned counsel appearing on behalf of the petitioner submitted. And both the counsels appearing on behalf of the petitioner, parties have submitted that the matter have been amicably resolved.
Yes.
And as such, a joint petition has been filed before this court. Full Be that as it may, it is relevant to take note of that the present proceedings is taken up at the under Article 227 of the Constitution, whereby taken under whereby an order passed under Order 21, Rule 97 and 101. An order dated 14/12/2015 passed under Order 21, Rule 97 and 101 have
Right.
been put to challenge. Full stop. Taking into account that a order passed in a proceedings under Order 21, Rule 97 and 101 comes within the ambit of a decree in view of
Section 3.
the specific provision of Order 21, Rule 103, this court would not have the jurisdiction to entertain the present proceedings. Full stop. Mr. Purkasta, the learned counsel appearing on behalf, Mr. Purkasta, the learned counsel appearing on behalf of the petitioner, therefore submitted that he may be permitted to withdraw the instant petition, and taking into account that both the parties have jointly have amicably resolved the dispute, they may be permitted to file appropriate application before the learned executing court. Full stop. Taking into account the above, this court closes the instant petition on withdrawal. Full stop. Liberty, however, is given to both the parties to file their application for compromise before the learned executing court.
And we'll make an application along with this application, my lord.
So, the copy, a certified copy of the instant you can take a certified copy.
Yes.
A certified copy of the application filed before this court may be also enclosed before the liberty also is given to enclose the certified copy of the joint application filed before this court,
Right.
before the learned executing.
Item 11.
Item 11.
Oh, you are there. So
Yes.
I was the right person to call you at the right time.
Right, ma'am. This case, my lord, I was asked to produce the certified copy because pinpoint query was made by this court whether, my lord, issues are framed. My lord, I have gone through these relevant orders. During the pendency of the stay, when the court stayed the entire proceeding because of the, my lord, miscase. On the next day, court has framed the, my lord, draft sheet. My lord, sorry, my lord, framed the my lord, issues on the basis of draft issues submitted by the defendant. And plaintiff could not, my lord, produce the, my lord, draft issues as a result of which court proceeded ex parte. And thereafter, my lord, they have challenged this order before this court. There is a stay order. We have filed an application for withdrawal of the suit with the liberty to file afresh.
When did you file that application?
Which one, my lord?
The withdrawal with liberty?
Withdrawal liberty, my lord.
You filed it on 16/5/2023.
Right, my lord. Absolutely.
This was at the time when pleadings were just completed.
Yes, my lord.
What is wrong with these courts? Well, what about the other side?
Other side, they didn't appear, notice was served. my lord. The court, findings of the court is that, my
So
lord.
many lawyers. Mr.
Oh, no.
Professor, you are led by a battery of lawyers in this matter. You must have taken all the other lawyers. Huh? You have Mr. A.K. Puskar, Mr. Noor Mohammed, S.N. Mohammed, A. Iqbal, so and so, so and so.
Because my Noor Mohammed was earlier.
How many more is required?
Noor Mohammed is earlier, my lord, he expired. He engaged me, my lord. Findings of the court is that, my lord, non-joinder of necessary party is not a formal defense. This is the only fact. And it was pointed out by the defendant in their WS, that number of legal heirs were left out. And we do, my lord, admit. We do admit it that, yes, there is some lapse on our part. Unless and until legal heirs are brought on record, my lord, as, my lord, plaintiffs or whatever it may be, decree may not be.
Mr.
Lord,
Professor, where is your petition?
Which one?
Yeah, where is your application order 23?
It is at page. Just to put this. It is at page, my lord, 83. Just to put this. At page 83.
Heard Mr. A.K. Pulkasper, the learned counsel appearing on behalf of the petitioner. First, none has appeared on behalf of the respondent in spite of service being meted out. First, the supervisory jurisdiction of the court under Article 2 to 7 of the Constitution have been invoked, challenging the order dated 9/4/2024, passed in Mizi case number 163/2022, arising out of title suit number 103/2022, whereby the said miscellaneous application was rejected by the Court of the Civil Judge Kamrup, Amingao, hereinafter referred to as the Learned Trial Court. Full stop. It is seen that the Learned Trial Court, by the impugned order, they rejected the said application on the ground that the suit have been pending since the year 2022 and substantial time and resources have been consumed. Full stop. It was also mentioned that if the petitioner was allowed to withdraw the suit at the stage without sufficient cause, the opposite parties shall be prejudiced. Full stop. In addition to that, the learned counsel court had also held that the petitioner had failed to make out a case of either formal defect or shown sufficient cause for allowing the petition under Order 23, Rule 1(3) of the Code. Full stop. This court have duly taken note of that the petitioner as plaintiff had instituted the suit against 5 defendants seeking a decree.
Page 55. Plaint. Relevant portion, clear portion is at page 59.
What is this suit for?
So, I also fail to understand, my lord.
How is it relevant?
The decree passed and cell deed number, some decree be passed that the cell deed so be substituting and binding upon the defendants.
So it is an agreement for sale,
Yes. And decree be
directing the
passed-
defendants to honor the agreement of the suit. If refuses to neglect, the honorable court may take necessary action on the law, pass on restraining them from entering into any disputed land.
It is defective. Basically, it is defective. He should have made a prayer for at least for right title interest on the stamp of the, or for execution of the registered salary. Registered agreement.
No, there was must be an agreement for sale.
Sometimes in the agreement, sometimes they are saying, my lord, it is a registered salary. In the pleading, it is registered salary. Prayer, it is agreement. At my very first para, my lord, para 2 of the plain. A registered sale deed. Being registered deed number 1128 dated 11/3/77. Another is 1277 dated 11/5/77.
Mr. Counsel, I think you should withdraw the suit.
My lord.
Don't seek liberty.
As lordship pleases.
No. You simply withdraw.
Right.
Do you know what you wanted? Seek cancellation, man. Huh? Mr. Bhagat, kindly come to the second paragraph
I got
of the
to-
plain.
Yes.
Second paragraph
Second
of the
para.
plain.
Yes, I'm, my lord.
It is most
is more
respectfully
respectfully
that the
stated
father of the plaintiff, so and so, had purchased a plot of land and measuring 4 bighas, 4 kata, 12 lechas by the registered
sale
sale deed number so and another by so and so from Iman to Iman. And since the date of purchasing, the land is in possession of the plaintiff and they are paying taxes.
Yes.
Okay. Now, what the plaintiff seeks,
My lord.
see the decree.
Yes. Relief of for. Decree be passed that the sale agreement
Dated transfer is subsisting and binding on the defendants.
Even. So that is one. So you are not asking for decree for declaration of your right title. You are not asking that. Then Yeah.
Saying that it is defective. Entire suit is defective. Where is bag, reap sought for is bag. It does not even in conformity with the pleadings.
So how do I give an order in your favor?
No,
Tell me, give me a reason I'm exercising 227. How do I give you?
if I simply withdraw the matter suit, then it may create some problem. Tomorrow they will come and say adjudicator. Of course, my lord, lordship knows, my lord, unless and until issue is decided. Therefore, it cannot be said to be a decree. Evidence not to that, issue not decided.
Adjudicator, it won't apply. Adjudicator cannot apply, but if you withdraw,
Order 2, Rule 2 and Section 12 will come. Because this is a court of justice, court of equity, my lord. Lordship understood the problem. Let him not be, my lord, non-suited.
but how do I add reason which is not there? I know the reason what it should have been.
I am also handicapped, man. I am.
You are not asking for declaration, you are not asking for remand. But if you have stated that you have not asked for declaration, a single word also in your petition is also okay. But that is also not there. But how do I exercise 227? I have to say something is wrong.
Simply lordship may withdraw the suit. And liberty is up to your lordship. Because, my lord, I have gone through some decision. Unless and until liberty is granted, then the first part of the order will become ineffective. It doesn't have any meaning. Simply lordship allow me to withdraw the suit. But it is not followed by, my lord,
No,
liberty.
you are always at liberty to withdraw.
Then tomorrow they will come and say,
No, you can always withdraw, but the problem is without liberty, you have a problem. That I understand.
therefore court says, my lord, it is.
I do one thing. I give you a liberty. I allow you to withdraw the instant petition, give you a liberty to file a review. Now come up with that grounds in the review of that order, or file a separate application why you want to withdraw, that there is no proper declaration sought for and all these things.
Then jump. Defendant is always there, defendant has filed objection.
But how do I do it? Now tell me, give me a handle, how?
Then, my lord, lordship may kindly give me some time so that I can find out some suitable solution, so that I can assist your lord. I
Please.
understand, my lordship is totally handicapped. Absolutely handicapped. And advocate, my lord, of course, he is no more. I, my lord, specifically, my lord, instructed him. Mr. Noor, and look at the pleadings. Possibly you will not get any relief, not even the stay order. But at the same time, you cannot withdraw because your prayer is rejected. Therefore, perhaps High Court may do some sort of justice to you.
But how do I, only way, if you can give me some handle, I can give you. I know the suit is absolutely without a year.
My lord,
You can't do that.
My
It is very wrongly drafted.
wrongly drafted, man.
No relief has been sought for
Nothing, man,
properly,
nothing.
nothing has been given.
He doesn't know what his case about, my lord. The plaintiff treated in such a way, he doesn't know what his case about. What is the relief sought for, he doesn't know. And what relief ought to have been, my lord, sought for, that was also not known to him. Once he is saying, my lord, somebody is, my lord, trying to dispossess him because permanent injunction was sought for. Meaning that, my lord, his title is clouded. Then he should have made a, my lord, relief for declaration of title interest.
So, Mr. Pugasta, you have some other matter today?
My lord, I am extremely sorry, my lord, I am just, my lord, about to make a prayer. Another, one more item is there, my lord. I may be excused for that, my lord.
Why?
My lord, I could not prepare the case, my lord. Item number 14, I request Mr. Nath. He is also, my lord.
Yeah, that is okay. We'll take it up after some time, that matter.
Right.
But we'll dispose it of today, this one.
My lord.
Let me give a thought
My
while
lord,
I'm dealing
I-
with
I-
other
I-
matters. What can be done?
My lord,
You will be there. Something way out.
my lord.
12,
Good slow, isn't it? Good slow, isn't it? Fast bole.
Wait, please, Your Lordship.
Yes.
Can be taken up at 4, Your Lordship.
Huh?
Council, can it be taken up at 4 PM, Your Lordship?
Why?
Senior Council wants to argue the method for VC.
What is the matter about?
The met.
Issue precept upon the documents affecting partition. District collector to effect the partition and take necessary action. Then,
Granted, trial court, while exercising its power as an executing court, issued a precept without giving us a notice. And without giving us a notice, issued a precept upon the district collector to demarcate the land by meets and bounds. And the DC, while doing so, has dispossessed us from by breaking our boundary wall.
so I'll read. I'll read. Then, what is this business out here? You're out.
Yes. sir. And
What
half
is
of
the
portion
status?
boundary has been, boundary fencing has been broken up by using JCB by the
Then,
district.
meanwhile,
collector.
considering the submissions made by the area, directed till the next returnable date, status quo shall be maintained in respect to schedule A land. You are in possession.
My lord, yes, this is a suit for partition, my lord. And my lord, he is a purchaser. The trial court has passed a preliminary decree by saying that his sale deed is valid, but with regard to possession, my lord, he cannot claim possession over any part of the land. That possession can be given to him only after the partition is effected,
Absolutely.
my lord.
Rightly. Then,
Then, my lord, the precept was issued, then, my lord, the circle officer has measured the land and then he has submitted a report, my lord. And, my lord, the case is at the stage of final decree, my lord.
Then?
At that stage, my lord, they have filed the instant civil revision petition by saying that, my lord, since no notice is issued to him, therefore, all the exercise, whatever is carried out by the deputy commissioner is bad, my lord. My lord,
notice for what? Whereby direct the area district collector to effect partition, further be pleased to pass an order directing the area to take legal action if any person raises any obstruction in the enforcement of the decree, and it shall be that matter be heard before passing an order. Let's see the decree.
my lord, decree, lordship will find at page 85, my lord. Relevant will be, my lord, 88, my lord, order.
Page, decree.
It starts from 85, relevant will be.
Declared and decreed that the plaintiff have joint right and possession. It declared the plaintiffs are entitled to recovery of 2/3 of the Schedule A land after partition by meets and bounds. And the decree where the sale deed and money will remain as valid sale to the extent quantum, however, so and so cannot claim possession of an exclusive portion, and their possession shall be handed over after partition, are permanently restrained from doing any act to the interest of Iman. Okay, so this is a decree where you are going for preliminary decree. Where is the preliminary decree? Issue a precept. So precept has been already issued. Then
Then, my lord, it was.
then why is this order passed? Tell me. I don't understand. Page 98. Not page 98. Page 97.
But what happened, my lord,
So they are raising objection.
some persons have raised objection, my lord. That's why at that time, the circle officer has submitted report that he cannot execute that part.
Oh, while carrying out that, they are causing problems.
And my lord,
Page
the
number 92,
objection
No,
is,
no, no, dismiss, dismiss.
objection as well as, my lord, there is water logging.
You have no business out there.
92, your lordship.
No, no,
This
no,
is not
no.
an objection raised by me. This is objection raised by defendant number 2 to the suit.
Whatever may be there, where the partition has been affected between the parties as per the, no, what is the duty of the revenue officer is to find out, take into account and then submit a report. They are not going to throw anybody out.
In the meantime, while doing so, they have even carried out, constructed a 20-feet road beyond the decree.
Who?
The district collector.
How?
That is the problem, your lordship.
You are making statement out there.
Yes, your lordship.
How?
They have not made the revenue officials a party in.
Then why you are not filing a writ? Huh? What type of case is this?
No road is made at, my lord. Only this thing, this land is about 30
Ah.
bigger land, my lord.
When do you want it?
18th of this month.
Okay, I'm not vacating it. I'm vacating the interim order.
No, your lordship.
No,
only
no,
1 week.
I'm vacating it. No, these type of orders cannot remain. My goodness, what is wrong with these people? It has been submitted that the senior counsel is, of the petitioner is not available to publish the matter again on 18th of July 2025. Full stop. This court is not inclined to extend the interim order passed on 3/10/2024 and accordingly stands vacated. Full stop. This court directs the district commissioner, the district commissioner Tinsukia, as well as the circle officer Tinsukia, Revenue Circle, to go ahead with the preparation of the report
My lord,
of partition of the
my lord,
suit land.
report is already submitted, my lord.
Final report submitted.
The report already submitted before the court. That order is page 99, my lord.
Report submitted.
Yes, my lord.
Plaintiff submitted Iman. And then partition has been effected between the mayor. It is seen that the matter is to be heard in presence of both the parties before passing or done. So it is only the passing of a final decree.
The
Yes, sir.
final decree, my lord.
Then what is wrong with this? Full stop. Leho. Dismissed. Itu থাকক গাও, again, is not inclined to vacated, comma, the learned court of the civil judge, senior division Tinsukia. It has been duly submitted that the circle officer Tinsukia Revenue Circle have already carried out the partition and thereupon submitted the report before the learned trial court. Full stop. The learned trial court is directed to pass the final decree on the basis of the said report. Full stop. This type of a case doesn't arise. Nikon ki, what is this? How can you stall a primary? Open लिख लेना. Heard Mr. Purkaster, A.K. Purkaster, the Landlord counsel appearing on behalf of the petitioner. Mr. None appears on behalf of the respondents in spite of service being effective. The petitioner has invoked the supervisory jurisdiction of the court, challenging the order dated 9/4/2024 passed by the learned court of the civil judge Amrut Amingam in midday case number 163/2022 arising out of title suit number 103/2022, whereby the said application filed under Order 23, Rule 1, Bracket 3 of the Code was rejected. This court have duly perused the said order dated 9/4/2024, and it is seen that even before framing of the issues, the said order issues, the petitioner, as plaintiff had filed the application for withdrawal of the suit with liberty to refile. Full stop. The learned counsel appearing on behalf of the petitioner submitted that has drawn the attention of this court to the plaint and submitted that the plaint has been drafted in such a manner that on the face of it, it would show that there is a formal defect. Here, the learned counsel drew the attention of this court that on one hand, the plaintiffs themselves have the plaintiff in the plaint. The learned counsel drew the attention of this court to the contents of the plaint and submitted that a perusal of the plaint itself would show that at paragraph number 2, it has been categorically mentioned that the plaintiff claim has a plaintiff claims title on the basis of 2 registered deeds of sale. Full stop. He further submits that the plaintiff also had stated that the defendants are interfering with the possession of the plaintiff and thereby clouding the title of the plaintiff. However, there has been no declaration sought for which was required to be sought for in order to succeed in the suit. Full stop. He therefore submitted that on the face of the plaint, he therefore submitted that the plaintiff on a reading of the plaint, that it was a formal defect. In addition to that, the defendants the plaintiff have also failed to bring on record there were various other that the plaintiff had his other brothers who ought to have been made parties to the suit, and without them the suit would not have proceeded. Full stop. He therefore submitted the learned trial court ought to have duly considered that said aspect of the matter. That too, when the application was filed at the first instance after taking into account the written statements so filed. Full stop. This court have duly perused the said plaint and have also taken into account the application under Order 23, Rule 1, Bracket 3 of the Code. Full stop. This court further have taken note of the order passed on 9/4/2024, whereby the learned court was more concerned that the suit was filed in the year 2022 rather than looking into as to what was the stage of the suit. Full stop. It is the opinion of this court that the suit so filed by the plaintiff had formal defects on account of not having adequate, not seeking adequate reliefs for the purpose of maintaining the suit, as well as also not impleading the other brothers of the plaintiff, which the plaintiff ought to have. The learned counsel appearing on behalf of the petitioner further submitted that it was on account of an incorrect advice so provided by the counsel who had prepared the plaint, and it was on such incorrect or mistaken advice the suit was filed. So taking into account the above grounds, it is therefore the opinion that the learned trial court ought to have allowed the application filed under Order 23, Rule 1(3) of the Code, which was the Code, and thereby allowing the plaintiff to withdraw the suit with liberty to refile. full stop. The learned trial court having failed to do so, comma, had failed to exercise the jurisdiction vested upon it by law, for which this court exercise is bound to this court for the this court is of the opinion that this is a fit case for exercising of its supervisory jurisdiction. Accordingly, the instant petition stands disposed of with the following observations and directions. Number one, the case number 163 of the 2022 stands allowed, thereby allowing the plaintiff to withdraw the suit with liberty to refile. Full stop. Number two, this court further imposes a cost of rupees 10,000 upon the plaintiff, which has to be deposited before the learned trial court as cost toward the cost before as a deposit a cost of rupees imposes a cost of rupees 10,000 upon the plaintiff. Full stop. The said amount be deposited by the plaintiff before the learned trial court before instituting any fresh suit.
163 or 2023.
Huh?
This case in my number is 16323. I'm online.
13,
Yes, Mr. Sahu. What is this?
Section 6 specifically said,
Then
trial court has not recorded whether he was disposed within 6 months from the filing of the suit.
and the only thing required is that
That is- that is the-
Your lordship will find, yes, your lordship. Lordship, in paragraph 16 of the judgment, there is two part of findings of this honorable court. Paragraph 16 of the judgment, the last part, Mayor, it lordship.
yes,
However, despite cross-examination, the PW2 and PW3, the defendant could not disprove the plaintiff's prior
page.
position. Page number
42.
42.
however,
However, despite cross-examination, the PW2 and PW3, the defendants could not disprove the plaintiff's prior possession and illegal ouster from the suit land. Thus, it is seen that the plaintiff has successfully shifted her burden of proving the case that she has been rightful possession of her the suit land and she was illegally dispossessed from the suit land by the defendant. Now, your lordship may kindly come to page number page number 47. Only findings, thereafter I will come the remaining parts, lordship. The last part, accordingly, it is held that the plaintiff was unlawfully dispossessed from the suit land and thus she is entitled to recover possession of the suit land. Consequently, this issue is also decided in affirmative and in favor of the plaintiff.
Mr. Sharma, only one thing.
Yes, lordship.
Where is the date when the plaintiff was dispossessed is the finding of fact?
Your lordship may kindly come to that question. Paragraph 15. So far the date is concerned, I will come to that part, lordship.
That
Now,
is the only question.
no, lordship, only month, first of that, whether in, the month which is within the period of 6 months prior to filing the suit. That is whether decided or not. However, your lordship may kindly come to paragraph 15. However,
In the month of June 2020, the defendant most surprisingly stored sand and rocks by occupying the suit land.
This is the evidence.
Lordship,
This is the evidence
this
is
is the-
coming. No, Mr. Sharma, problem is this. This is the evidence he has come.
and the so far. the
Now,
is-
where is the finding? Show
And
me
so far
the
the issue
finding.
number 2, your lordship may kindly.
I'm not
see.
on that. Mr. Sharma, show me one line, I dismiss his petition. Where is the finding of fact reached when the plaintiff was dispossessed? Show me that line.
Lordship, therefore, I pay before your honor, lordship, come to the issue number 2. Issue number 2, whether the suit has been filed within the prescribed period of limitation.
Where page?
Page number 37. According to the plaintiff, she was dispossessed from the suit land in the month of June 2020, and the instant suit was filed on 12/10/2020 within the prescribed period of limitation. On the other hand, the defendant have pleaded nothing in this regard to the period of limitation. As such, it is held that the suit is filed within the prescribed period of limitation. Accordingly, the issue number 2 is decided in affirmative and in favor of the plaintiff.
When was the plaintiff dispossessed? The learned trial court goes on the basis of he pleads this, he does not plead that. That is not the issue. There has to be a finding of fact when the plaintiff was dispossessed.
Lordship,
Secondly,
yes, sir.
whether the dispossession was without, otherwise in accordance with law. These are the two aspects.
Yes,
When was the plaintiff dispossessed is where is the finding?
Lordship, when the issue number 2 has been decided by this honorable court,
No, that is not the question now. This is not how you do it. If that is there, then why do you have to go for other aspects?
Lordship,
Why do you have to
there
issue
is
issue
two
number
part of
4?
questions that needs to be determined by this, by the learned court below, where suit is decided. Because
The
Lordship,
court, the suit or the trial court ought to have categorically come to that finding. When the plaintiff was dispossessed and whether he was dispossessed without due otherwise in accordance with law. That's
Lordship,
all.
when the issue number 3 has been decided by this honorable court, honorable court has, Lordship briefly discussed the entire part of the disposition and as well as the,
When was he dispossessed is where is the single finding. That is the reason. I was not allowed to issue notice in this matter because, but only reason I've issued because there is not a finding to the, there is no other question. Isn't that Mr. Sahu? He raised many other issues, but this is the only ground. When was the plaintiff dispossessed? You want more time? Prepare.
tomorrow, the Lordship. there.
Not tomorrow, after vacation. Mr. D. Sharma, the learned counsel appearing on behalf of the petitioner, respondents, seeks some more time, taking in some more time in the matter, who's taking into account the above, this is the matter on 21st of July, 2025, interim order passed earlier. Shall continue.
Highly obliged.
14,
Prepare the case on the lordship and keep the matter on next Wednesday.
Yes, what have you done as regards the defaulter?
Bona fide.
No, fine.
My lord, I conveyed, my lord, my instruction. My client is very confident on the default.
Very well. Chalo. We have it after vacation then?
My lord will give me a date, of course. Because they are having the stay in their favor, and we have not had an execution.
Record has come.
Record is here.
We've seen that the records have come. Good stuff. Mr. D. Chakraborty submits that the matter requires urgent disposal, taking into account that there is a stay operating. Taking into account the above, list the matter on 22nd of July, 2025 at 2 p.m.
Interim order till that.
Interim order passed earlier shall continue till then.
15,
Yes, what is this?
Lordship, this case, I filed a petition wherein the challenging an order passed by the learned court below, wherein the cross-examination of the plaintiff witnesses were dispensed with in connection with the case.
10/5/2025.
Lordship, it is the EBS for setting aside the
Page?
order. Order is at Lordship. Page 56, annexure 9. This is the order.
How many witnesses?
Witnesses were three in number.
Huh?
Three in number.
All three had come.
That I do not have any knowledge about that, but one of the witnesses, the plaintiff himself, he was present at that particular point of time.
What present, ma'am?
All were present.
Yes, sir.
Okay. 10,000 into 3, 30,000. 30,000 cost.
Actually, we may be allowed to cross-examine, but the amount of
30,000
cost
cost.
bit less.
Okay, make it 15 into 3, 45,000 into
30,000.
one chance.
My lord, otherwise he is very negligent, my lord.
So 30,000, only one chance. I fix a date. I
Yes.
directing him to appear.
All,
I fix a date on the next day.
Yes.
The court will fix a date. And on that date, you bring your witnesses
Yes.
and he will cross
the same day.
on the same date,
Without-
depending on that is for the court to say.
Yes.
Because if he takes the whole day for one, the other
Yes,
may not be
yes, sir.
permissible.
And my lord, that may be observed that no further chance may be, adjournment may be allowed.
No adjournment is for them.
Yes, my lord.
They cannot take any adjournment
Yes.
if first of all, when a witness come, question of adjournment is zero. There's no adjournment question.
The Lord trial court, my lord, as per provision of law or 47.
He has done it.
It is passed.
He has given it that on that day, but the problem is that the lawyer was not there.
Yes.
The lawyer's mistake.
It is
For
not-
that, they are paying that 30,000 penalty and plus another appearing before the court also, they must have spent some amount. It is not free of cost.
Yes,
So they have suffered a bit. I hope they remember.
yes.
I'll pass appropriate directions. Okay, heard Mr. Pidas,
Yes.
the learned counsel appearing on behalf of the petitioner. Mr.
MJ Kadir.
So-and-so who appears on behalf of the respondents. Full stop. The petitioner herein have invoked the supervisory jurisdiction challenging the order dated 10/3/2025, whereby the application filed for recalling the order dated 1/8/2024 was rejected by the court of the civil judge, Senior Division, Hailakandi. This court duly takes note of that on 1/8/2024, the plaintiff witnesses were present, but the counsel who appears on behalf of the defendant failed to appear. And it is on account of that, the learned trial court passed an order that the suit shall proceed to the next stage of defense witnesses. It is under such circumstances an application was filed, being petition number 506/04, recalling the order dated 1/8/2024, stating that stating the reasons as to why on that day when the witnesses were present, the cross-examination could not be done on behalf of the defendant. Full stop. The learned trial court rejected the said application, taking into account that the explanation so provided was not proper, and as such, declined to recall the order dated 1/8/2024. Full stop. Full stop. Next. This court have duly taken note of that that there has been certain negligence on the part of the defendant in proceeding with in pursuing the said litigation. First, be that as it may, on 1/8/2004, the reason why the plaintiff witnesses was not cross-examined was on account of the lawyer of the defendant did not appear. First, taking into account that on account of the lawyer, the client should not suffer, this court is of the opinion that a further chance, if given to the plaintiff defendants to cross-examine the plaintiff witnesses, would be in the interest of justice. First, next, this court cannot also be unmindful of the fact that the plaintiff with three of the plaintiff witnesses have come before the court, and because of the and any order passed now would again result in the said witnesses having to endure, have to again appear before the court. Full stop. Full stop. It cannot also be said that there was no negligence on the part of the defendants. Full stop. Consequently, this court is of the opinion that a reasonable compensation ought to be imposed upon the reasonable cost have to be imposed upon the petitioners. Petitioner. For the interest of justice. Accordingly, this court disposes of the instant petition with the following observations and directions. Full stop. The order dated 1/8/2024, whereby the learned court had closed the cross-examination of the plaintiff witnesses, is recalled. Number two, this court imposes a cost of ₹30,000 upon the petitioner, which has to be deposited before the learned trial court on the next date so fixed hereinafter. Number three, this court further this court, taking into account the stay order passed on 16/5/2025, by which money suit number 1/2021 pending before the learned court of the learned civil judge Hailakandi was stayed, is hereinafter is vacated, and the parties who are duly represented are directed to appear before the learned trial court on 14th of July 2025. Full stop. This court directs the learned trial court to fix a date as per its convenience for the cross-examination of the plaintiff witnesses. Full stop. Next. This court, number three, it is further observed that the full stop. On that very date, on appearance, the learned না না, এইটো for cross-examination আগতে দিব। Fixes the matter on 14th of Iman, full stop. On the same date, the petitioner shall deposit the cost of rupees 30,000, full stop. Which, full stop. Upon such deposit being made, the learned trial court shall fix another date for cross-examination of the plaintiff witnesses. Full stop. It is made clear that if the said amount of rupees 30,000 is not deposited, the trial court shall proceed with the further, proceed with the suit. It is further, it is made clear that in the circumstance, the learned trial, the petitioner, the defendants do not deposit the cost of rupees 30,000, the learned trial court shall proceed with the suit in the manner in which it is otherwise proceeding. Disregarding the order, the observations and directions passed in clause 1 herein above. Next. First. Next. This court further directs the learned trial court that upon deposit of the said amount of rupees 30,000, the trial court shall fix a date for cross-examination of the plaintiff witnesses. Next. The petitioners here, the defendants shall not be entitled to seek adjournments on the ground on any, shall not be entitled to seek any adjournment when the witness is of the plaintiff witnesses are present on on such date as may be fixed by the court's learned trial court or on such adjourned date of hearing. Next. The petitioner, the plaintiff would be at liberty to file appropriate application for release of the said amount of rupees 30,000, and on such application, the learned trial court shall pass appropriate orders.
Item 16.
Yes, what is this?
Lordship, it's an appeal against the MSCT award, Lordship.
Ground?
Ground, there are two grounds I have taken, your Lordship. First of all, the salary certificate was not proved actually, Lordship. This proprietor was summoned, but he instead coming, send one professional CA, Lordship, who appeared on behalf of the proprietor, and salary was taken as 14,900, Lordship, and that was disputed, Lordship, and he has already stated in his cross-examination that the proprietor's name and signature was not there. And secondly, Lordship, dependents has been taken as 4, but they were not made a party in the claim petition. Only the claimant number 1 was the claimant in this case. But the Run Tribunal has awarded the compensation to other 3 dependents, Lordship. But they were not made a party, nor no statement was recorded, Lordship. These are 2 are the grounds.
How does the court, the tribunal come to know about that?
Lordship, maybe they have stated later on, but on record, Lordship.
This is left behind his son, wife, son, father, mother.
Mother and
in
one.
distress.
Yes.
Then
Again, Lordship, they were not made a party, Lordship.
who?
The claimant didn't made a party. They were not in the claim petition, Lordship.
So is it required?
Lordship, but their names are not, they are not as a claimant in the case.
So
This is my ground, and Lordship, funeral expenses has been given as 25,000.
Huh?
Loss of estate has been given as 30,000.
which one?
In the award, Lordship, page number 21.
Award passed when?
What was
25. Okay.
it? 12/3/25.
Then the amount should be more on this.
Lordship, I know.
But Lordship, on the last occasion, asked me to make some calculation. So I have come with some calculation, Lordship, liberally. Lordship, as per my calculation, Lordship, it should come 20,51,800. I'm not for the insurance company or a claimant, Lordship. I'll just make a
Okay, okay.
relying
You
on the
do one
given.
thing. You do one thing.
And I have taken, Lordship, the monthly income, the minimum wages, which is now for the unskilled labor, Lordship, as per the notification 2022, it should be 10,121 because the salary certificate was not proved.
But what did he start? Why you are going into the unskilled thing?
Lordship, he was only a employee of one drug distributor. He cannot be a skilled one.
What was he working as?
He just stated that he was employed under some drug company, drug distributor company.
What was he working as?
But LCR will reveal, Lordship, but here again.
Hello, we
Yeah.
do one thing. We admit it on these 2 grounds.
Good.
And you deposit this 20 lakhs. That is
50% right now.
20 lakhs.
50%.
No 50%, that 20 lakhs which you have come into.
Yes, Lordship, yes.
Yes.
Lordship have finally disposed them. Lordship make.
No final dispose. I'm taking into account because here there is interest of 7.5% is there na?
Yes, Lordship, we have also agreed for the
Huh?
interest part also. We agree to pay the interest.
What? You've taken the interest?
No, I haven't taken the interest, just only the amount.
So as
The
per
final
you, it should be 20 lakhs.
Plus,
Now the question is, their case is 14,000.
yes, 14,900 taken.
So you, as per you, it is 10,000.
That's per
So
day.
as per your calculation, you pay that amount of 20 lakhs.
Plus,
Then whatever may be, you want to pay with interest
yes, yes, yes.
You want to pay this?
It's accrued, we are ready to pay.
on this along with
Yes,
interest you pay.
Yes,
And what else you have done? 40,000 and yeah.
sir, I have taken the filial consortium also. That's
What
why.
is this? General damages, 10% of general damages me?
But 70,000 plus 10% because it's.
Oh, on conventional
Yes,
heads.
solvent. 10% increase as per foreign settlement. Multiplier should be 16.
So you do,
I have taken four
you do one
dependents.
thing, huh?
4 dependents I have taken, the genuine dependents, those are.
Okay,
Given.
you pay this amount along with interest.
plus.
And then whatever amount they will release, that is gone. So the interest amount is taken care of for you. Because at the end of the day, you have to pay.
Yes, sir. We
So
are,
this should be the minimum as per the Minimum Wages Act. So we'll see later on if they come up with anything, then only on that amount there will be
Yes.
some interest. Heard Mr.
TJ.
This is
TJ
an
Verma.
appeal, upor akhil likhi di bade. This is an appeal filed under so and so, so and so, so and so. Mr. So and so, the learned counsel appearing on behalf of the appellant has submitted that there are, how many grounds?
2 grounds.
Which one?
Grounds, first of all, the disability certificate, we have disputed.
And?
Sorry, the income certificate, sorry, Lordship.
And?
Second one, the number of dependents,
That is no problem.
number of dependents. Done.
Submitted
Award
that
now-
the sole ground of objection
Yes, sir.
taken in the instant appeal is that the
Salary certificate.
salary certificate having not been proved, the learned tribunal was not justified in arriving at the amount of rupees 14,900 as the monthly income of the deceased. He submitted that in absence of the monthly income certificate in absence of the monthly income certificate being proved, comma, the deceased could at best have received an amount that would have at best be adjudged as would have been entitled to the monthly income of rupees 10,127.25 paisa, which is as per the Minimum Wages Act. Full stop.
Notification of Government of Assam.
Aha. This is it.
This latest, I think. Latest one.
Wages Act as notified by the government of Assam by notification dated
Dated 24/22.
2022. Full stop. Taking into account the said grounds of objection, the instant appeal stands admitted. Call for the records of so and so. Stay on a divo. This is an application filed under Order 41 Rule 5 again likhitibo stay away. Full stop. This court, having heard the learned counsel appearing on behalf of the appellant, comma, and taking into account that the appellant insurance company duly admits that the monthly income of the appellant, of the deceased, ought to have been rupees 10,000, 127.25 and not rupees 14,900, had inquired with the learned counsel appearing on behalf of the appellant insurance company as to what would be the amount to which the appellant insurance company admits the liability. The learned counsel duly submitted a calculation sheet which is kept on record and marked with the letter X. Full stop. In terms with the said calculation sheet, comma, the total compensation as per the appellant company should have been rupees 20,51,800. Full stop. In that view of the matter, this court states the impugned judgment and award dated so and so, passed in so and so, subject to deposit of rupees 20,51,800, along with interest at the rate of 7.5% per annum. From the date of filing of the case
Date of file.
before the registry of this court. Full stop. This court further observes and directs that the claimant would be at liberty to file application before the registry for release of the said amount. Full stop. The registry, on such application being filed, after carrying out necessary verification, identification, and after taking into account the bank particulars, transfer the said amount to the claimant. Full stop. I extend this.
All right.
Supplementary item 43.
In the previous day, Lordship had asked me to find out what the minimum wages of application just prior to the accident. Lordship, I have got a copy of it.
You have also come up with similar things?
So whatever your Lordship decides, my ground was first the involvement of vehicle.
Not involvement.
Saying that GD entries doesn't show immediately. But obviously charge sheet was against.
Charge sheet was given. So then becomes very difficult. Now,
He's a class 10 student.
huh?
17-year-old student of class 10.
Oh, the 17-year-old, na?
This notification just prior to the accident.
So your ground is the monthly income could not have been rupees 13,704. Taking into account that he was a class 7, a 17-year-old boy, isn't it? So as per you, how much?
That's still 9483.
Huh?
This prior to the accident, the accident occurred on the month of, on 2nd May 2021. This notification is of 17th March 2020.
So you come with a calculation of this and place it before this court. I'll ask you to pay this amount, like the earlier council did,
Tomorrow or today?
whenever you feel.
Tomorrow.
Day after? List the matter again on 13/6/2025.
With this amount also 9.
You come up with 9483. 9483, na? You come up with that. You pay that amount, then we'll release that amount along with interest, whatever it may be. Just come up with all the facts and figures.
Item 17, hearing under Order 41, Rule 11, CPC.
Your case, good case, bad case, which one?
My lord, the matter was heard on the last occasion.
And then also I don't frame a substantial question of law means it was a bad case. You means that you don't want to answer that and you want what I should say.
I was hoping for a sympathetic view, my lord.
No, I don't have sympathy. Sympathy has gone. Sympathy is there outside.
My lord, a simple query was put to us on the last
Yeah,
occasion.
fantastic.
The query was whether the first appellate court, while passing the judgment, came to a finding that the property involved in this matter is undivided, unpartitioned ancestral property. My lord, so far I went to the judgment. There is no whisper, my lord, that it is undivided property. This is the will matter, my lord. Will was executed in the year 1982. Gift was executed in the year 1982.
Then?
And the donor, he expired in the year 1973.
Oh, yes, yes.
Page 37 is the finding.
Hmm?
Page 37 is the finding. It's page 36, para 12.
Hello, what are your substantial question of law? Let me be a bit sympathetic to thee.
A lot of the index.
Failure of the plaintiff to prove her gift of the suit plan made by her father necessarily precludes the plaintiff from the plaintiff. What is your suit? Let me see, plaint.
Malord, my suit was based on a gift deed.
Suit for declaration, confirmation of possession and recovery. There is no counterclaim.
There is a counterclaim.
Okay.
By the defendant number 1.
And
But-
how many appeals filed?
We have filed 1 appeal. I am the plaintiff.
Your suit dismissed.
Suit was initially decreed. In first appeal, the suit
I
was
am asking you now, suit is dismissed,
as of now dismissed here.
counterclaim decreed.
Counterclaim decreed to the extent of mutation, partly decreed.
So you are
No
not,
right title interest. The right title interest has not been declared in favor of the counterclaimant as well.
okay. So you have not therefore, you are only aggrieved by the dismissal of your suit. Not the decreeing, part decreeing of the counterclaim,
Actually, I am aggrieved by the part decreeing of the counter,
not the dismissal of the suit.
not the dismissal of the suit.
Are you sure?
Sure.
Then how does your first substantial question of law come into picture?
My lord, my name was mutated in the revenue record. It was mutated on the strength of gift deed. My gift deed goes. I understand that part. My gift deed goes. My question here is, my lord, I cannot claim absolute right title interest over the suit land on the virtue of gift, since the gift deed has not been considered. But what about my right over the suit land by virtue of inheritance? At least to that extent, a very limited prayer.
So how many sons and daughters are there?
Total 8 sons and daughters. 8
8 sons and
daughters, 3 sons and 5 daughters.
5 daughters.
No.
They will have a right,
They can file a partition suit, my lord.
but they have a right to what was there? What is,
But the thing is that, my lord, she,
what did the trial court, the first appellate court do?
first appellate court has dismissed the suit on 2 grounds, my lord, that the gift deed could not be proved, and secondly, on non-joinder of necessary parties. The other daughters have not been made a party,
Then
only on those 2 grounds.
that couldn't have been the ground taking this is a suit for declaration. Is
Declaration,
being seeking a declaration against this defendants.
the court has held that, my lord, since
Other
claiming
daughters
the
are not
gift deed,
creating
not
any
necessary.
problem.
She's claiming the gift deed from the ancestral property, so other is a necessary.
Why do you need the other people a party? Other parties are not agreed by that. This will be the declaration personam. So that cannot be the ground of the dismissal of the suit. And the second is, the gift was not.
Gift was not.
Okay, so that is it. Now, what does the counterclaims do?
Counterclaim we had sought on the basis of, my lord, partition among the brothers. There are 3 brothers, my lord. So we have sought that as per oral partition, we have divided the property amongst ourselves, that is 2 bigger 3 quarters of land, leaving aside one bigger of land to them, to the sisters.
Then,
That was also not considered. Because we have failed to give any pleadings in that regard. Only evidence was adduced, but there was no pleading.
okay, now why is he asking for mutation?
And we had also sought for in the counterclaim to cancel the mutation that was given to her on the basis of the gift deed.
Then,
Since the gift deed was not proved, so the mutation was cancelled.
because the mutation was made on the basis of the gift.
Gift deed.
So,
My lord, what I seek is a very small modification of the order, if
I can't do
possible,
that.
if permits.
I can't do that. The fact, they ask for cancellation of the mutation. How can they put any amount out there because the mutation was only on the basis of that? The gift deed.
A small observation will also serve my purpose, that as legal heir, names of all the sons and daughters can be muted. Then I don't have to go for unnecessary litigation of partition because the suit land is in my possession. It is only the revenue part that is concerning me.
Why do you need the mutation? You're already in possession,
I am in possession.
so go for mutation. Divorce the decision, cancellation, you are at liberty to seek for mutation.
What I was presuming, my lord, what I was presuming was that if my mutation is cancelled, that too on the strength of a decree passed by a competent civil court.
But that cancellation is only divorce. vis-a-vis the give deed.
Give it, I understand, my lord,
It
I
will not
understand.
impact your but the question is, how can the court go into you have not sought for partition? When you have not sought for partition, how can this court pass that order? The courts could have passed that order. And to be a substantial question of law, it has to arise from somewhere. It cannot come before this court for the first time.
A slight clarification of the order, Your Honor, if permissible.
How?
What about the mutation part? That is the only part I am aggrieved with.
You do one thing, ask for mutation. Ask for mutation out there. Let this appeal be pending. Ask for mutation. Let them say that, okay, give a PR that, okay, mutation has been cancelled so much on the basis, but now I have a right of mutation on the basis of inheritance. Ask for that. Then if you ask for that, if they don't, you read.
Right.
But how can I say anything out here? Anyways, the second one, without declaration of absolute title of a heir can cancel the mutation. We cancel the mutation of the claim can be. You challenge the gift deed.
We challenged it.
That gift deed was allowed. The challenge was allowed.
That challenge, my lord, their gift, they could not prove it, so they sued for
No,
gift.
they can't prove it is different.
We did not challenge.
That is your. You don't prove it, you may not get a declaration. But can the mutation be cancelled? Without there being a challenge to the gift deed. You may not get the declaration of right title in interest. You only challenge the mutation.
Mutation and declaration of right type. Only mutation,
Your declaration has been not given.
not gift.
And the right title mutation was cancelled.
Mutation was cancelled.
On the basis, he couldn't
He
prove
could
the
not prove
gift
the
deed.
gift. Yes, ma'am.
But has the court arrived at that there was no gift?
Yes, ma'am, because the donor expired in the year 1974 and the gift was executed in the year 1982. So the court held that since he expired before the execution of the gift, so there could not have been any gift, ma'am, in favor of the plaintiff.
So there was no gift.
No gift.
Is there a finding?
Yes, ma'am. Para 12, that is correct.
But there is no challenge to the gift.
No challenge to it. It was an oral gift. As per them, it was an
Oral
oral
gift.
gift. Oral gift.
Or you failed to prove. And you got the mutation on oral gift.
Oral gift.
So when should we fix a good date for dismissal of this case? When? We do one thing. We dismiss it. We'll dismiss it, but make an observation to that.
I'll be obliged.
Not today, some other day. We'll dismiss it, but make that observation that
Yes.
cancelling the mutation has to be only construed as cancelling only because there was no valid gift.
Gift, yes. Yes.
As the mutation was only obtained on the basis of that gift.
Gift,
Oral
yes.
gift. But oral gift not there, so yeah. Be that as it may, if the petitioner is, appellant is entitled to, they may very well seek remedies on this. So that
Yes,
I
ma'am.
can pass an order.
That was actually my plan. Yes.
Huh? Hello, some other day, when?
As your lordship, please.
You see. I'm always here. You, both of you are, he is the most busiest counsel.
Monday.
23rd, ma'am, at 2,
23rd, I have matters on there.
25th.
17th, 24th. 24th at 2.
Deeply obliged.
Obliged. No more order 41. Let me take up other matters. Order 41. Yes, what is there? Urgency?
For the degree of eviction is there. We are
Eviction.
we are the defendants and plaintiff suit was for right title interest and recovery of possession.
Then?
Our case is that we entered into an oral agreement and thereafter permission was taken in the year 1992. And thereafter we were in possession of the suit.
Where are your substantial questions of law?
We have
Page-
taken adverse possession plea that was not considered by the page 4 and 5.
This purpose holding the defendant illegally dispossessed the plaintiff from the suit land without there being any proof of discussion of evidence for illegal possession.
An issue was formulated, Lordship, on this.
Whether the decision thought by the decision number is 2
Was filed in the year 2009.
The defendants illegally dispossessed the plaintiffs from the suit land without there being any proof or discussion of evidence for illegal dispossession. Who was in possession of the suit land?
We are in possession of the suit land.
And
After oral agreement, Lordship, we were put in the possession of the suit land, Lordship. And thereafter, Lordship, we obtained permission for sale of the land, Lordship, in the year 1993. That was exhibited, permission exhibited as exhibit call, Lordship. They filed a suit in the year 2009 saying that we disturbed in their possession.
when was the possession, means oral agreement?
Oral agreement, Lordship, 92.
Huh?
Oral agreement 1992.
1992.
Then, Lordship, in 1993, we obtained permission.
Permission. Then
Then they filed the suit in the year 2009.
2009. Then,
Beyond 12 years, Lordship.
okay, then
There is a specific pleading by the defendants that the suit lands were in our possession beyond 12 years. So we have taken a plea of adverse possession, Lordship.
how?
They did not sell the suit land to the
Let's see your written statement.
page 27, Lordship.
What does the plaintiff say?
Page 27, written statement, Lordship. As per terms of oral contract, the defendant paid rupees 20,000 on about 10 to 1992.
He views to possess the suit land by cultivating the same from year to year. The defendant number 1 by the name of so and so by taking advantage of having his own land on the northern and western side of the suit land made an abortive attempt to trespass into the suit land by denying none. Paragraph 28, page 28. No. Please, no case.
Page 28.
Adverse possession, no case.
Lordship, adverse possession is there in second paragraph, Lordship.
What?
More than a period of 12 years without any paragraph, second paragraph.
Can that be a plea? Can that be a plea?
Lordship, on the basis of that sale permission, Lordship, 1993.
So what? Where is your
Since-
statement?
Since then.
You
we-
say that you are possessing our land on the basis of the sale, oral sale. Eh, oral sale. Kindly
No, Lordship,
see,
Oral,
kindly see page
sale
27. Page 27 say, that the plaintiff few days after receiving of the payment of the heir had told the defendant that they now decided not to sell this entire land as agreed by the oral contract, but to sell so and so land and so and so. The defendant, when paid this entire sale price of this land, agreed to be sold on bona fide of an oral sale agreement. Finding no alternative, agreed to purchase the land as agreed upon by the plaintiff. Accordingly, the plaintiff put signatures on the application for obtaining sale permission for the Iman on 93. Then after obtaining the sale, the plaintiff again approached that they would be going to sold only the land measuring so and so instead of Iman, and this time the defendant resisted such change of terms of the agreed Iman, and the plaintiff in turn assured that they would surely execute the sale deed very soon and on delivered possession of the land under oral sale
Sale
agreement dated so and so on Iman, and the plaintiff also delivered a sale deed number Iman executed by so and so or Iman in Iman as security of their part performance of the contract, subsequently being transferred mutually and amicably on oral sale agreement. Thus, that a purchased land of the defendant from the plaintiff. See, purchased land.
Lordship. that
Kindly
is
see the
written,
word,
but in the
purchased
entire
land.
Abatement, Lordship, it was a deed of agreement. On the basis of that deed of
You're saying you claim your title through the plaintiff, but you're saying that where is the question? I've been here for 12 years. Why? You can't throw me out. So adverse possession goes. Then what else?
and the
Let's
defendant
see
has
the
for-
findings.
Findings, they are saying that the two contradictory pleas I have taken, that is by the appellate court, Lordship.
Judgment finding where is the opinion has agreed to sell 3 bighas, 1 katha, 10 acres of land, oral sale degree where taken possession in terms of year, whether the Iman where was dispossessed. Issue number 3. Issue number 4, 5, 3. Have claimed that they have right, title, and interest of the suit. Admittedly, the defendants are in possession of the as decided in Iman, the defendants have failed to prove any oral agreement in respect to the suit land. So it is unambiguous that the defendants have illegally dispossessed the plaintiff from the suit land. Rightly so.
Lordship, I have reduced the evidence of DW 2 and 3. They admitted that it was already agreed upon to sell by the plaintiff in favor of the defendants and the amount was already paid.
But you failed to prove that. Where is your counterclaim?
There is no counterclaim, Lordship. But the suit is itself barred by limitation, Lordship.
How?
1993 permission was obtained by the defendants for purchase of the suit land. And since then, we are in possession. Suit is of the year 2009, Lordship.
No. He still continues to have title. Whether did he ask for declaration of right, title, and interest?
Yes, Lord.
Oh, then over. He had the title. If he had the title, matter is over.
And they asked for a money decree also, Lord.
What?
Page 14, their declaration for right title.
Decree that passed declaring right title, well done. Recovery of possession, money decree for mean profit amounting to 5,000. Money decree for present and future mean profit 5,000. Inquiry be made for ascertainment of the present and future during pendency of the decree. That case. Hello. One second appeal, I think I should dismiss today. One tenant, landlord, tenant done.
Lordship, this is a case where they are possessing since 1992. They have taken
Madam,
money.
can't help it. The law is very clear. You have no right. Unless you have you should have filed a counterclaim. You have not filed a counterclaim. You did not file a suit for specific performance. What is your business to stay there? The moment he proves his title, this is the judgment. I have delivered 4-5 judgments also on this.
I'm admitting. On the-
Once he has the plaintiff has the title, then the plaintiff wants you to vacate, forget about dispossession or possession becomes immaterial. Your question is, you have to then say why you want to have a better right. The moment you are challenging that, no, I'm not going to give it, that cannot be the ground.
As per Ravinder judgment, he can.
Which
claim
one?
his- Ravinder Lordship, he can claim right title on the basis of adverse possession also. Lordship.
There is no quarrel you cannot claim. You can very well claim right title interest on the basis of adverse possession, but your pleadings are insufficient. You by yourself have stated the word purchase land.
Only on this paragraph, otherwise, Lordship, in.
Other to there is no paragraph only.
Lordship, in all the paragraphs, it is written as that, Lordship, there is an oral agreement in between plaintiff and defendants, Lordship. Thereafter-
Anyways, chalo, we dismiss your case on. If your case. If it is closed. 17, we dismiss your case. They passed the order only. Others are waiting. 17.
Then after.
No,
petition,
এটা
Lordship.
বেলেগ এটা কাম এটা আছে ন আধা 17 2 p.m.
Obliged, Lordship.
আৰু order 11 will be.
Stay matter item 37.
May be allowed to withdraw Lordship.
Huh?
May be allowed to withdraw Lordship.
Oh, I remember.
Morning I have made mention Lordship.
The counsel appearing on behalf of a petitioner, Mr. So-and-so, submits that the petitioner expired and as such, and as the instant proceedings was personal to the petitioner, the question of substitution of the petitioner does not arise. He therefore submits that the instant proceedings have become infructuous. Accordingly, because in that view of the matter, the instant petition stands closed as it has become, stands closed as abated. The stay order dated 22/5/2023 accordingly stands vacated.
38.
What is this?
Amendment at the stage of appellate stage. Lordship. That was rejected against them. Imperial order is at page 49. In this case, Lordship, our suit was for specific performance of contract that was dismissed. And thereafter, during first appellate stage, we filed an amendment application.
What is the amendment speaking?
Lordship, we are, as our deed of agreement was not signed by one defendant.
Where is the amendment petition?
Page 41.
Amendment of the plaint?
Yes, Lord.
Proposed amendment. Changing the dark numbers?
These are the schedule, Lordship. May I read the first paragraph, Lordship? Page 41.
Huh?
First paragraph, page 41. That the suit has been filed against the 10 defendants for recovery of valid and delivery of cash possession from the defendants by virtue of Bynama agreement dated 7/12/2005, fixing sale price of the suit land at so-and-so on receipt of advance consideration of rupees so-and-so. Thereafter agreed to sell the land on receipt of balance amount of so-and-so. The Bynama contains rider that on disposal of title appeal number 35 and 36 filed against them, that is against the original owners, by Enamuddin Lashkar and his father in respect of the suit patta land, the defendants would inform the plaintiff by post. The learned district judge Hailakandi dismissed the appeal and ended in favor of the defendants, and the defendants did not complete the sale process in favor of the plaintiff. The plaintiff has filed title suit number 2/14 against the defendants for specific performance of contract. That amongst the executants, the defendant Saira Begum Lashkar, daughter of late Shaukat Ali, did not appear and sign on the agreement, and including herself in the suit. The suit has been filed under specific performance of contract. The relief being discretionary in nature, the learned lower court did not grant the relief and dismiss the suit. Now, this is amendment portion, Lordship. Now, the plaintiff appellant is filing this petition for amendment of the plaint for deduction of the share of unsigned non-executant of the concerned Bynama for the total land involved in the plaint, the executants being 10 in numbers, and each of them carry title to an extent of 1/10 share in respect of.
So you want to reduce it?
Yes, Lordship.
You want to reduce their claim.
They want to reduce the claimant, but the suit was dismissed on some other.
That remains. That remains. What they want to do is, it is something like part of the claim of the suit is being withdrawn. This is not an amendment. This is not an amendment of the plaint.
Thing for your lordship notice, my lord, they filed the appeal in 2017 after dismissal of the suit, my lord. And this amendment petition they are filing, it is a suit lack of diligence, my lord, in 2023.
No, what they are trying to do is, they are giving up a part of the claim. This is not an amendment in effect. What they are saying that earlier we filed a suit for specific performance against this larger plot of land. Now, taking into account that some of the persons who were the owners did not sign, so their part be reduced. And accordingly, we are seeking specific performance of a lesser part. If I'm not wrong, that is what they want. They want a reduced area. It's more like a giving up a claim in respect to the bigger part. Why should you be angry? You should be happy. You have to fight lesser. I would say this is not a year, but it is giving up a claim of certain areas of land. That's all. It is not an amendment, stricto sensu. It would actually, they want is that they give up their claim in the suit in respect to certain portions of the land.
But they were aware of the thing even before filing, during the filing pendency of the suit, my lord. They could have done it by that time.
Mr. Rajbharvi, kindly listen to Order 23, Rule 1 says, even without the leave, a court can give a part of it. Without the leave also, that can be given. Any part of the claim one can give it. Now they say they initially asked for 100. Now they are asking for 50. We don't want that 50 because
Then
those
after
50.
the matter once being adjudicated, mal. They could have
Understood.
done it earlier.
So they can very well reduce it because an appeal is a continuation of a suit. So therefore they are reducing their claim. What they are not asking for anything else. So they are reducing the claim. Whether they get or not, that's their lookout. I would have understood if they increased. If they increased, then obviously.
Reducing.
So they are reducing their claim. So therefore the amendment could have been allowed. But if it is a case of increasing, obviously, then I would have been different. The question would have been different.
Change the nature and character of the.
why was the appeal dismissed?
One of the ground that one of the executant has not put her signature in the agreement. That is one of the ground, Lordship. I have annexed the judgment. But Lordship, appellate court rejected only on the ground that at the appellate stage, amendment cannot be granted. There is no
Appellate
sense.
stage amendment can be allowed, but
Yeah.
here this is not an amendment in a strict sense of.
In fact, Lordship, abandonment of
And
part
that
of
is
my
a
claim,
village
Lordship.
stage, my lord.
It ought to be abandonment of part of my claim.
It's an abandonment of a part of the claim. Earlier they were asking for more, now they want to reduce it. Whether they get it or not. In fact, the appeal, the ground of appeal, you have a case on that, the question of, you can't dismiss the suit, the toto. It could have been effective, a decree could have, of specific performance could have been passed against so far as those persons who signed it. See
So
section
9
13 of the specific relief act makes it very clear.
For judgment of the suit, my lord, of course, discloses other things also. Of course, not this, apart from this point, my lord, there are other things also in the judgment of the suit, my lord.
This is, they want to just correct it. They want to reduce, or they want to actually, it is more like giving up a claim insofar as that particular area. That, I don't think there's any harm out there. And do you want to omit those? You have not asked for striking out those name of those persons then? Should have asked for striking out the names in the
Only
plain.
Lordship proposed amendment only in respect to the area. Prayer
But how
page-
does it
page
make
43.
sense? If you don't want the striking out of those
After-
names.
Lordship may be striking out Lordship for the defendant.
That is too much.
It is humbly prayed that your honor may be pleased to consider the rival controversy of the parties and on perusal of the facts, attendant circumstances of the matter, to allow amendment of the plaint as per the schedule of proposed amendment of the interest of proper adjudication of the appeal. And this is only one ground. On some other grounds also my suit was dismissed. So Lordship, after this, they also have a good case in other grounds also, Lordship. Even after Lordship allowing of this amendment or abandonment of claim, Lordship, they have a good case in other grounds, Lordship.
That is different,
Lordship.
but the question is there, it is more like an abandonment of a claim,
Lordship.
by which the amendment, they are reducing their claims from what was there earlier. What is that you are reading?
Order 23, Rule 1, Lordship.
See,
Withdrawal of suit or abandonment of part of claim, Lordship.
that one.
And that is, Lordship, at any time after the institution of the suit, the plaintiff may as against all or any of the defendants abandon.
So you can even omit, okay, I don't know, like, want anything against him. You may say, okay, I don't want to proceed against it. That is your, because he is the dominus litis. You can do so. But if he can, if he wants that, okay, I want to amend this, abandon this, and file a separate suit, no. Anyways, chala. Heard Ms. R. Chaudhary, the learned counsel, appearing on behalf of the Commissioner, Mr. N. Raj Bolhuia, who appears on behalf of the respondent numbers 1 to 10. The present petition has been filed invoking the supervisory jurisdiction of the court, challenging the order dated 7/6/2023, passed in title appeal number 13/2017 by the Court of the Learned District Judge Hailakandi, whereby the application being petition number 253/4/447 filed under Order 6, Rule 17, read with Section 151 of the Code for amendment of the plaint entitled suit number 03/2014 was rejected. First up, this court have duly taken note of the order, so impugn order so passed by the learned trial, by the learned court of the district judge Hailakandi, whereby the reason why the said amendment application was rejected was on the ground that the said amendment application was filed at the belated stage, that too at the stage of hearing of the appeal. Full stop. It was further observed by the learned First Appellate Court that the prayer for amendment of the plaint at the appellate stage cannot be allowed. Full stop. This court have duly perused the application so filed seeking amendment of the plaint, and from a perusal of the said application, it transpires that initially the plaintiff sought for specific performance of an agreement dated 7/12/2005 against the defendant numbers 1 to 10, who are the respondent numbers 1 to 10 herein. However, the defendant number 5 did not appear and sign the said agreement. And as such, she was not bound by the agreement for sale dated 7/12/2005. It is under such circumstances, so much of the right of the defendant number 5 over the suit land, the plaintiff wanted to abandon her claim, and it is under such circumstances the application was filed seeking amendment of the plaint only to insert the reduced area of the land which the plaintiffs claimed are entitled to specific performance. Full stop. It is seen that the learned trial court, First Appellate Court, did not consider, the learned First Appellate Court had considered the application seeking amendment of the plaint had considered the application so filed as seeking an amendment of the contents of the plaint, but without taking into account that the plaintiff have actually sought for abandonment of their claim insofar as the defendant number 5, and thereby seeking specific performance of a reduced area. Full stop. This court further takes note of the provisions of Order 23, Rule 1 of the Code, as well as of the fact that the appeal is a continuation of the suit. Under such circumstances, it is the opinion of this court that the plaintiff, even at the stage of appeal, was at liberty to seek abandonment of a part of the claim as well as against some defendants to the suit. In that view of the matter, the learned trial court, First Appellate Court, ought to have allowed the amendment application to the plaint. Accordingly, this court interferes with the impugned order dated 7/6/2023 and allows the amendment application being petition number 253 of 447 filed under Order 6, Rule 17 of the Code. This court accordingly, full stop, with the above yeah, full stop. Next, the petitioner, herein who is the appellant in the appeal, is directed to file the amended plaint before the learned first appellate court on or before 27th of on 27th of June 2025. First, both parties are directed to appear before the learned first appellate court on the said date. First, it is observed that if the amended plaint is not filed on the said date fixed, comma, provisions under Order 7 Rule 6 Rule 18 shall ensure.
39.
Yeah, Mr. Rajburi, the question of filing a written statement doesn't arise because they are reducing the amount. Stay order, the stay order stands vacated and parties are directed to. Yes, Mr.
Lordship, here as per office note dated,
Don't go by office note. What is the order?
the order is at last page, page number
Hence, in
67.
exercise of the power, the appeal is posted for recording of evidence. Demand so judgment could not be delivered. Appeal is adjourned. Yeah. What is wrong?
Lordship, here two connected revision petitions are filed.
Huh?
Two connected revision petitions are filed. One revision petition has already been allowed by your lordship. I have the order.
For what?
This order has been set aside.
This very order?
Yes.
Why?
Similar matter, Lord, arising out of the same title.
Same appeal.
Same, two different appeal, Lordship, but arising out of the same title.
Which court?
Additional district judge number 1.
Eh?
Additional district judge number 1, Kamrup.
So you wanted some reasons. What is the reason?
That is not specified by the appellate court.
Let me put the reasons and not interfere. Where is the petition? Under Order 41 Rule 27.
None of the parties filed petition.
Eh?
None of the parties filed petition. The
What?
Yes, the appellate court itself passed it.
And where is the other side? The other side therefore is not appearing.
Lordship, the last order 20 to 7, two of the
Huh?
last order, Lordship, 20 to 7, two of the respondent refused, only one remaining, Lordship. If Lordship allows, I can take steps for paper publication.
Service complete.
Not completed.
Why?
Two of the respondents or Lordship refused, one insufficient evidence. But
Huh?
they are part of the same family, Lordship.
Where are these people?
They are from
Nearby.
nearby.
Hello. Release this matter again on 23rd of June 2025. Whose petitioner is directed to effect service by way of dusty upon the respondents who serve routed through the registry of the court and file an affidavit of service on or before the next date. So in time order passed earlier shall continue till then.
40,
Yes.
May I please, your lordship?
Ah,
Lordship, in this
what are you
case,
challenging?
I challenge the order again, order dated 13/12/23,
Hmm.
passed by the civil judge number 2 in title suit number 131/21.
Then,
Against the ex parte order dated, Your Honor, 26/11/21.
then,
And your lordship allowed me for stay order on 10/4/24.
oh, yes, yes, after a long time. You filed an application for filing written statement, didn't it?
No, Your Honor, no, your lordship, opposite party filed.
Huh?
Opposite party filed, on last occasion, and they want some time to file written statement. Oh, in the main title suit. Sorry. I filed
Filed written
petition.
statement. That written statement was rejected.
Yes,
And it
your
is
lordship.
under such circumstances you have come. Yes, we have to allow it. You see the
Yes.
state of affairs.
They have filed, my lord.
You should be on this side. You are otherwise a legal aid counsel.
Correct.
You should be helping the petitioner. You should not be fighting out this thing. Because of the fact that this is, after all, she's a lady out there, not her. So, yeah. Now, there are serious allegations being made against her on respect to something is there. What is this case for?
For declaratory suit, my lord.
For?
Declaration that the that the defendant is not the wife of the.
Ah, that is what. Ah,
But Your Honor,
you take your seat. You
okay.
take your seat. Ah. Then
My lord, fact of the matter is that,
I should allow.
my lord.
Here, Mr. Sen, you should also be not only a duty towards your client, but also a duty towards your legal aid counsel, which you sometimes adorn the role of it. Chalo, allow korish. File your written statement. On when?
Fact that application was filed under order.
We have already filed, Your Honor, but
Under order.
You are also legal aid.
I'm also.
Both legal aid.
Yes, my lord. Now, my lord, we are fighting. Legal aid versus legal aid.
Legal aid
Now,
versus legal
yes.
aid. for
Now,
filing.
now.
Chalo, where, written statement ready or not?
already filed, Your Honor.
You filed?
Yes.
Okay. To be accepted. Huh? I can allow more order deeding. Allow. Stay order stands here. Vacated and parties will appear on 21st July before that court. Okay? Disposed.
41,
Elite versus. Yes. What is this? You ready?
I'll try my best, madam. I'm not very well versed with the civil law.
Don't need to be. What is the order?
The impugned order is at page number 137, where my application
Ah.
for amendment of the plaint to the extent of inserting a consequential relief to evict the defendant number 2 and her heirs were
Where is your
not,
application for amendment?
the application is at page number 128, madam.
Mr. Counsel. What is the amendment you are seeking?
My lord, the prayer is at page number 130, my lord.
Ah.
If I may read.
Hmm.
It is therefore prayed that the honorable court be pleased to consider the above and be kind enough to allow the plaintiff to amend the plaint by adding the additional consequential relief of eviction of the defendant number 2 so and so with her sons and men and material from the suit land with demolition of the unauthorized houses. and
How,
structures.
Mr. Purva, your counsel is who? G. Chaudhary. Chalo. He is not available. When is he available?
Coming Thursday.
Huh?
Thursday or Tuesday, whenever, my lord.
Not so long. This is not a matter for Tuesday business. This is a Monday, not even a Monday matter. Monday is a bad day for these type of matters. When?
Friday and Monday.
Does your, I'm not saying because you don't do writ matters, but first of all, this counsel, does he know that amendment applications are not filed like this? My goodness, what is wrong? Can't help it. Hello, when?
Friday then, my lord.
This is the matter on 13/6/2025. To stop interim order, pastorally shall continue till then.
I'm so obliged, my lord.
Orders, no?
44 and 45.
My lord, in the previous case, the interim order may continue.
Huh?
My lord has extended the interim order.
Huh?
Okay.
Yes, what is this?
Suit is not maintainable and an interim order was passed, injunction order was passed that we have challenged. And this honorable court has was pleased to stay that order, lordship, injunction order.
Why service is not complete?
Service is complete, lordship. That flag one also is there, lordship.
Shows that with regard to the notice upon respondent by way of the state, so and so has not been received.
But she has
Regard
received.
been received for respondent with purported signature of respondent.
Yes, lord.
Service had not been received. Then
She has received it. Signature I have checked, lordship, in the acknowledgement card. Her
no,
signature
that is what they are saying. They don't purport it. Why this purported is being used? Why you are not able to serve?
We have taken steps. She has received the copy.
How do you know?
I have checked the acknowledgement.
How do you know? Did she sign it before you?
Not for me.
Then-
Trustee service I have not done,
Then
but I have
check the
taken the
service.
step.
That is why at least the service has seen that the service upon all the respondents is complete. If it is complete, then with regard to the notice upon demand by way of usual process, so and so has not been received.
Usual process has not received, but service report as per order, office note dated 11/2/2025, service report AD card received with signature X1, lordship.
What are you challenging here?
Here, lordship, I am challenging the injunction order in 77, lordship.
Injunction order?
Yes, lordship, wherein before that, lordship, it's a minority institution and it's covered under the Minority Institution Act, lordship, and the certificate also I have. annexed.
Age? Which order you are challenging?
I'm challenging order, I am challenging 8/1/24, lordship, which is at page 60, lordship.
Page 60. Why is this not an appeal? Appeal file against this?
No, lordship, we have come on as CLPIO.
Why?
It's the injunction order.
Why? Isn't this order appealable?
Because there is no jurisdiction, because it's a minority institution, I would like to take Lordship, as per, because it's not appealable, because jurisdiction is not there, it's quorum non-judice lordship.
Then you challenge the suit on that basis, not the injunction order.
Because non-governmental institution, as per the definition of the Assam Non-Governmental Education Institution Regulation and Management Act.
Whatever education manual, if it is an injunction order, I only understand the simple language. It's an appealable order and you have to file an appeal. Now the next date is fixed out there. You are challenging that order, na 60. Accordingly, an ex parte in interim order is allowed. The OPs are directed to pay half the salary year, issue notice on year for appearance on 26 to 2024. What happened there?
Then, in the main suit, we have filed our, taking this plea as quorum non-judice, no jurisdiction, so we have filed our written statement in the main.
How can there be a stay? We vacate this stay. Vacate, no, I dismiss this petition.
Lordship,
No,
may it be fixed on Friday, this Friday, Lordship, I will satisfy Lordship on this count, this Friday, 13th.
with cost.
No, Lordship,
With cost.
because there is, they don't have this thing, Lordship, jurisdiction, because as per, it's a.
I have the jurisdiction to impose cost. That you
That
remember.
Lordship has.
You remember. That
We
is
have
with
all-
cost. 13th. For admission. 13 for admission. As first item. I am the second bench.
Lordship,
First item with cost. First, I start the day with 15,000 cost. 15,000. Impossible. How is an appeal being, how are you filing a 227?
Lordship, interim order.
No, my conscience does not permit this type of orders. It's laughable. Luckily, earlier the counsel who was appearing, he did not say that. Today, one thing good, I'm not imposing the cost. I'm putting that costs whenever Mr. Adhor appears. The imposition of cost will be on his hands on that date.
For orders item 19.
Matter having been heard, list the matter on 16/6/2025 at the top of the list. These two. So
19.
15, 30,000 cost. Next, item 19.
For orders item 19.
Service not yet complete. List the matter after completion of service. Steps for service of upon yet, so. Steps on service of notice upon response number, yeah. List for admission as well. Could you This is matter on 16/6/2025 at 2 p.m.
20.
Here receive it, take it now. Okay, service being complete. Service being complete, LCR having been received, list the matter for hearing in the usual course, liberty given to both the parties to file appropriate application for early hearing.
21.
AK order.
22.
22, no affidavit of Dusty.
But I have filed it. I have filed the affidavit.
When?
No, 3/6. I have a copy.
Mr. S. Das submits the affidavit. of Dusty has been filed on 3/6/2025. Full stop. List this matter again on interim order there.
No, my lord.
Okay, list this matter there on 26/2025 along with the said affidavit of service.
23,
This matter, my lord.
23,
Kindly see the last order, my lord. 23,
23.
RSA.
What happened?
My lord, the plaintiff number 3, my lord, she had died and during the pendency of the suit. I got that instruction, my lord. So your lordship directed them to verify. They are the plaintiffs, we are the defendants. As to,
My lord, my senior,
But the senior has to come and give a stamp of approval that the plaintiff number 3 had died. As it start working out there in the GMC. No, I'm asking you. GMC gives the death certificate. Or is he a lawyer?
yeah, mature.
Okay. LCR having been received, and the parties are duly represented, this the matter of for hearing in the usual course, liberty being given to both the parties to file applications for early hearing. 23 to order hold.
24,
Contact and find it out. If you need,
But
you file.
copy,
Now, if somebody died,
yes.
then you may have to file an application. And in that application, it has to be filed in such a manner that, because then it will be a case of remand. That application I can't consider. That application has to be considered by, yes, Mr. J. Ahmed. I'm told that you have
Yeah,
started working out there in the
No, my
GMC.
lord,
Yes.
I got instruction
Oh,
that Halima, he actually died.
plaintiff number 3 expired.
Yes. He expired on 1/8/15,
1/8,
2015,
1/8/2015.
during the
Okay.
pendency of the trial. And no substitution has been filed.
You did not file.
Yes.
So it has abated against you.
Against
So there is no require to stop. Mr. J. Ahmed, the
is
learned
Bhatta.
counsel appearing on
Yes, sir.
behalf of the respondents
Respondent,
who were the plaintiffs in the suit, submitted that the plaintiff number 3 expired on 1/8/2015 when the suit was pending. And there was no substitution so made insofar as the plaintiff number 3 is concerned.
here, defendant number
Accordingly, the suit,
3.
so far as the plaintiff number 3 is concerned, have stood abated on 1/8, na?
1/8/2015.
1/11, na?
90 days.
1/11/2015 itself. Full stop. Under such circumstances, the decree so fast. Plaintiff got the decree, na?
Yes.
Suit was decreed in favor
Yes.
of the plaintiff. The decree so passed could not have been passed in favor of the plaintiff number 3. Full stop. It is, however, a different aspect as to whether the decree could be severable or not, which shall be taken into consideration at the final hearing of the present appeal. Full stop. Under such circumstances, the question of substitution of the respondent number 3 in the instant proceedings does not arise. However, the name of the respondent number 3 is struck off. As the suit had already abated insofar as the respondent number 3 oblique the plaintiff number 3 is concerned. Pusto. It is also seen that the records have been duly received. Pusto. Accordingly, list the matter appeal for hearing in the usual course, liberty given to both the parties to file application for early hearing.
I maybe take liberty to file, take steps for setting aside the amendment if.
You are not, you are an appellant.
Yes, my lord.
He is appellant.
Hello.
And that is
But I
not possible.
I can also.
That is very difficult. You ask Mr. Dotto may help you. You can provide a death certificate so given by Mr. A photocopy of the death certificate so furnished by Mr. J. Ahmed is kept on record and marked with the letter X. Yes, 25.
24.
Petition from of a family member from Guwahati to Barpeta. I am for the wife. Restitution for conjugal right member. Marriage was solemnized in Barpeta. Thereafter they were here, Guwahati.
Okay.
So I pray for.
Taking into account that the respondent is not represented today, comma, list the matter again on 23rd of July 2025. Interim order passed earlier. Interim order is there, na? Shall continue till then.
25.
Service not complete. Regards. Number 2 and 3. You are paying for 2 and 3.
So far 2 is concerned, they are really my lord, and it can be deemed to be served because they took the steps on 29/4/2025. Now, placed unserved notice, no AD card or unserved notice of respondent 2 has yet.
Service is not complete as regards 2 and 3. Fresh steps have been taken.
But the 2 may be deemed to be served because it is over 30 days. So in terms of order 5, rule 9, first provision, my lord, your lordship can accept.
What is this matter?
My lord, your lordship will find the.
It is a matter, your lordship, judgment, against the workman compensation, but in this case, the run over a railway case.
The lordship can
Kiel,
be
sir.
seen.
Judgment is defective.
Who has filed this IA?
My lord, they have filed it.
There's a delay, your lordship, limitation.
Who are you?
I am in a company, your lordship, but they have said that respond number 3 is under our company, your lordship. This is was, but it is not checked, it is not proved.
Your lordship will find at page 22 of the judgment.
IA is whose? Yours?
Yes,
they are
delay,
right.
your lordship. I
Okay.
am for the.
IA is yours. What is that IA business?
There is a
for
delay.
delay, your 49 days.
Delay. How
Delay
much?
because 49 days, yeah.
We condone?
That your lordship may condone, but your lordship kindly see here.
Ah.
My lord, the order is passed against the railway authority to pay 10 lakhs and odd. Now, railway did not file an appeal. The service is complete, yet then, my lord, they are not paying. In the meantime, my lord.
Who is not paying?
The railway authority, my lord. The order, your lordship kindly see at page 22.
Page?
22 of the
Of?
MFA.
Who are you?
I have the company, your lordship, under the railway, your lordship.
Huh?
I am the company, construction company under the railway, your lordship. Case 22 can is the order, your lordship.
In view of the other, this is the claimant so-and-so is awarded so-and-so plus Iman because 10 lakhs only on account of her husband so-and-so in a vehicular train accident arising out of and in connection with so-and-so. Ordered that the OP General Manager NF Railway to recover from OP number 2. Who is OP number 2?
The company, my lord, he worked under that company, my lord.
They claim, your lordship.
OP number
one
2.
rule of
Judgment has
law,
come
they have-
and you are saying they claim.
Directed and in course of his employment under OP number 2, it is ordered that OP number 1 General Manager NF Railway is directed to recover from OP number 2 and deposit the said amount of compensation with the undersigned within 30 days from the date of this amount liable to OP. So,
Yes, 46, your lordship.
Ah.
The railway authority has the letter to the, that directed to deposit this awarded amount. In fact, we are not the, respond number 2, your lordship, op number 2 is one Durlab Gogoi, care of our company. But that Durlab Gogoi is never our employee. And it is a case, and they also.
He was a worker under what? Why was Dulab Gogoi brought in? By the claimant, the decedent died during the course of his employment under OP number 2. Dulab Gogoi, care of the world's company under NF Railway.
The work relates to, my lord, the construction of the railway work, and the railway, my lord.
Is he under your employment, that fellow?
Never,
Huh?
never our employee, your lordship. They made the party, our company, but it is never our employee. The Durlab also, the disease also never our. This is the case. And it
This is was not your employee.
not our employee.
How do you say so?
They cannot prove your
The
lordship.
court must have come
Nothing
to
was-
some
nothing
finding.
was proved before
Judgment
the-
is very clear, my lord.
Huh?
Judgment is very clear.
They never produced any certificate or any appointment letter.
At
nothing
page
else.
19, your lordship will find.
Page?
Page 19, my lord. In the middle,
The claimant also submitted at the time of year was old and he was received 10,000 per month and on pay. Registered and notified. Number so and so was submitting a written statement. Admitted. The fact that the claimant petitioner, deceased husband Ria, was appointed by him as a mohorer to the contractor under NF Railway. He also admitted that there is cause of action for the claimant. Okay. Written statement,
Written statement, I have annexed your page 12.
page
12. Argument also I have annexed. Draft 4. yes.
they did not give the evidence, my lord. What is the evidence?
Not to meet party and. 8 also. yeah.
Where's the annexure 1 and 2?
Sir, one,
Annexure 1 contract document of OP number 1 and 2.
contract document I have annexed your lordship.
So here he does not say he not admitted. OP number 1 never admitted as employee of the deceased. Then why does the court come to that finding?
I don't know your lordship. Case, that argument also I have annexed the railway, contrast is the case, I have annexed the argument also railway, your lordship, written on page 15.
In the opinion admitted that he used to pay his mohora so and so late salary. Where does he say
Wrong
that?
finding, wrong finding. Page 15, argument of the
Let
railway.
us see the findings. In the course of hiring, the claimant also stated there was agent and so and so police report, so and so salary statement. Salary statement
Nothing is that. Argument, railway argument, your
heard
lordship.
there was submitting the notion and the claimant stated that the salary on the learned counsel for the OP containing the monthly of the stated by the claimant mentioned after hearing the learned counsel if I submit the monthly salary of the deceased as demand. Mr. Datta,
Milord,
how is it possible?
Milord, in the judgment, your lordship will find.
It
But if
seems
there in
something
the
is
written
wrong.
statement, it is not there.
Anyways, that is another date. We first have to look into, we have to condone the delay.
Yes, that we have no objection.
And what about 2 and 3?
Two can be deemed accepted, and three is, my lord, the. yes,
Name is mentioned, address is not.
Three,
put
my
together.
lord, insufficient address.
You are doers construction.
A name is also.
Why you have been brought into the picture?
I don't know.
Because here the party who has been made a party is doer company.
Towards. Not
That is different.
different,
Then why you are coming into the picture?
because they have made a notice.
Huh?
Railway company give a notice, page 46, yeah,
Page
46
of the,
of this April, memo which is. Page 46 of memo. which
48,
is they give a
48,
notice,
my lord.
then we come to know about this case,
page?
46. Ask the company to pay the awarded amount, your lordship. Otherwise,
They are the contractor of railway, my lord.
Huh?
we are
They are the
contractor of
contractor
railway.
of the railway. The construction work was carried on there.
No, that locality, we are not constructed company. Another company was started, but
Who constructed?
another company, I have annexed that document also, page 23,
Page?
23, your lordship. Message, page 23 of my. The Patsala area, your lordship.
Mrs. Who did
Method,
it?
BR, Brentford, Tax LP Alipur.
Huh?
In the top message, BR, Brentford, Tax LLP Alipur.
So you are a third party who have nothing to do with in the proceedings. You are not the doers.
Similar, name similar, that's page 8 of the petition. I have annexed the claim petition also, page 8, your lordship.
Huh?
Page 8.
Have you written it to them? You have nothing to do.
Your lordship. Claim petition, your lordship, I page annex.
Have you written to railways about this thing that we have nothing to do?
We have already intimated, your lordship, but they have written a letter, they have deducted or. But railway is not accepted, your lordship. We have already intimated that we have not received notice and that that this is also never our employee. And Durlab, we will.
But how do I condone the delay? Because if this is that not person concerned,
And Durlab Gogoi also not related to us.
huh?
That Durlab Gogoi, respondent number 2, OP number 2, but not, he was never our employee. We do not know about him.
Then why they filed this appeal, my lord? I couldn't understand. If they are not involved at all.
Because they have, I have received a notice from the railway. Then we have entered into the matter and come to know, because railway, even
Hello.
notice that we have asked me to deposit. Then we have entered into the matter and come to know about this case.
We'll take up this matter some other day. This has a lot of implications. When do we
It is a run over of railway case.
Coming Monday. On next Monday.
16?
16.
This is the matter on 16.
God bless.
God bless.
27.
Service complete. Only against respond number 6 is not, no?
Teams are, because he's only a driver, it's nothing to do with it. Just we are asking for a pen recovery in this case, Lordship. That was not given because route permit was not valid at the time of accident. And
What
we
is
have-
the IA for?
IA for continuation of delay of 16 days in preference.
Okay. I heard Mr. So-and-so, the learned counsel appearing on behalf of IA. Mr. M. Talukdar appears for the respond numbers 1 to 5, comma, this is in 1 to 4. 1 to 4, who's the owner of the vehicle, who is the respond number 5, is also, has also been served. Full this is an application file seeking condonation of delay of 16 days, 16, yeah? Of, in preparing the accompanying appeal against the judgment and award dated so-and-so, passed in MSC case number so-and-so by the learned court of so-and-so. Full stop. Taking into account the grounds and reasons so assigned in the instant application, the the delay of 16 days is condoned. Accordingly, the application stands allowed, comma, application stands allowed. The registry is directed to register at the accompanying appeal and list the matter appeal for submission on in the week commencing from 23rd of June.
So my name may be reflected in the appeal.
What?
My name may be reflected in the appeal, Lordship.
You know what to do. You look into it. You must be
28
having
and
good
29.
life.
Obliged.
28, 29.
I have taken steps, but perhaps my 11th friend has not received the copy.
What is this?
The condonation of 34 days, man. Condonation
They have filed a
application.
cross appeal. And it's a, there is a delay. I don't know how much delay.
34 days.
Our appeal has been admitted that questions have been, substantial question of law has been framed. So they, in the meantime, they have also filed a cross appeal and there is a delay. So this is
Cross appeal. Is the cross appeal permitted? Under the RERA?
Actually, court can examine that. I will also examine.
Is a cross appeal permitted under the RERA? Because what the RERA says, this court shall decide the appeal by formulating substantial question of law. Okay. But it does not bring in the scope of Order 41 Rule 22. Then if Order 41 Rule 22 is not there, can you have a cross appeal? I'm only asking you.
When there is any order which is adverse to my this one, then I must have some kind of remedy.
The right of filing an appeal?
I file an appeal.
Is it a cross appeal or an appeal?
An appeal.
So it's an appeal, then it's okay. So there's a delay condonation.
there is a delay. I have not received a copy and.
So you have not issued notices to be issued.
No, notice have been issued. I have taken steps in the registry, my lord. He has not got. I will serve a copy.
Okay. You are for the other side.
For the,
Mr. So-and-so will. Yeah. So, I এখন কি আছে 1425 IA 1425 only. You accept notice on 1425? You accept notice?
can accept this now, if you
Then
serve me a
you will
copy-
serve a copy.
Lord.
Mr. So-and-so accepts notice on behalf of the respondent numbers 1 and 2. Good stop. He submits that he will take instruction as to whether he would like to file objections to the instant application. Good stop. List the matter again on 16th of July 2025. In the meantime, liberty is given to the objection to the opposite party to file objection if any.
Good.
It may
30.
be tagged along with my appeal also, my appeal. also.
That is already typed.
You need that.
My lord,
Why do you need that?
appeal will not, that has been.
Your appeal is your appeal. His appeal is his appeal.
My lord.
Where do you want the tagging?
But it has been tagged today.
Who has tagged? There must be some order somewhere. And if it is there, it is well. I'm not going to tag. Now let's come to the next one.
30.
Service complete upon respondent number, whereas it is not completed, else here has been received. Respondent number 2, service is not complete.
There's no other respondent, my lord. There's only.
Service upon the respondent number 2 is not complete, leaves the matter of the completion of service.
My lord, there's only one respondent.
Huh?
Only one respondent.
Respondent number 2 is not complete.
30, my lord. I appear from Mrs. Birla Corporation.
Oh, what else? Yet কি এখন লাইছে? কে বলি কেন হয়?
Appellants, my lord. The respondent is only one.
কোথায় তো বলে? Respondent number 2. Service being complete leaves the appeal for appeal on 16th of July 2025.
Can it be after 18th?
On 21st of July 2025.
31,
Hearing. Service. I think we have to be completed to have been completed. Okay, service complete. LCR is here. Interim order is there?
No, Lordship.
Who? Taking into account that the service is complete, leaves the matter on 24th of June 2025 for admission.
16 in the trial court.
The registry shall ensure that the scan LCR is received by then. Huh?
The trial court on 16, it is fixed, Lordship.
Tell the court, they will know what to do.
Lordship.
Matter of re-examination. Matter of re-examination of witness.
Re-examination. Okay, till the next date, the matter shall, the proceedings before the learned trial court shall reinstate.
Oblige, your Lordship.
32,
We'll finish it off next date. If I'm there in the bench. Yes, transfer.
I'm
Where do
seeking
you want to go?
from Guwahati to Silchar, my lord. This is a restitution proceeding, and in Silchar there is a
Taking into
review
account
proceeding
that
is
the
taking part.
respondent is not here, list the matter on 25th of June 2025. Interim order passed earlier shall continue.
33,
The matter is a compromise settlement arrived between both the parties. A deed of compromise has been already drafted. That matter may be disposed of with a direction to file a prepare application for joint compromise petition before the court. It is a matter is, subject matter is that plaintiff claim 5.5 license of land. Defendant admitted. Application for order 12.65.
I remember your case. Where you are the father.
No, I am the brother, one of the defendant number one.
It's okay. But all have not been served. It's okay. Service is complete.
Yes.
Service being complete, list the matter again
So
on
that may be.
18th for admission. We'll finish up admission. Interim order is there?
Yes.
Interim order passed earlier shall continue till then.
Most of it.
34, 34,
It's the matter again on 21st of July 2025.
35,
Complete upon the respondent numbers 1 to 3.
Yeah, okay.
Service complete?
I appear for the respondent.
Okay, service is complete. Now, what is this matter about?
Your lordship had directed the ONGC with regard to an arbitral award to deposit 60% and 40% by bank guarantee before the executing court. Now, Sibsagar, the district court doesn't have a bank account. Then in the meantime, the matter was transferred to the civil judge as the commercial court. The civil judge also does not have a bank account, because of which the amount has not been able to be deposited. And therefore, we are praying that if it can be directed, ONGC be directed to deposit before the registry of this court.
Item number 35, list on 13/6/2025 at the top of the list.
If you will.
36,
Yes, what is this?
Decree, your lordship, for inclusion of the observation made in para 43 of the judgment.
I made the mistake.
No, lordship.
What
The
happened?
registry did not put the para 43, which was in favor of defendant number 2 to 11. We were the defendant number 2 to 11 in the main suit. Now,
Item number 36 to be listed. Service complete?
we have served a copy to the decree holder appellant.
Discuss matter again on 25/6/2025. At 2 p.m.